Yes. Yes.
Order 41 rule.
Please.
My lord, for inclusion,
Pardon?
for inclusion.
What matter?
First step.
First step hearing we are not taking. Yes.
My lord, the urgency is there. My lord.
Hearing we are not taking.
My lord, I am
New application, new file.
Application. Is there any application?
Application.
What is the heading in your mentioning slip?
That is inclusion. Mentioning for inclusion, can.
No, write whether it's an application under what heading it will come.
My lord, I'm seeking my lord's leave to file the second appeal. My lord, what happened that the certified copy of the title suit, judgment and decree has been misplaced by the appellant. My lord, I'm giving the Xerox copy of it. Well, my lord, I'm applying.
The appellate court is there.
Appellate court is there.
Leave is granted. I'm going to leave them to file without. Yes.
File with us.
I'm prefer listing the matter under the hearing.
Under compelling circumstances, kept a beard. You're looking totally intellectual.
Talking about
Totally intellectual.
Somebody saying
Totally intellectual, but if you are mentioning a hearing matter, forget it.
no. Absolutely not.
What are you mentioning? Yes.
Millard, order 41, Millard.
Handover.
Difficulties, Millard. Monday is the date fixed in the executive.
No, handover. Order for 12 matters are immediately. Whenever it comes, we are taking up every day.
Your lordship, for application for inclusion in the list.
Application, yes.
The matter be placed as a mention, my lord. Although the application for injunction has not been disposed of, my lord, it is showing in the website that it is disposed of. I mean, that is why, my lord, it was already mentioned earlier, but the matter could not be given under
Oh,
hearing
please hand over. It will appear as 2 minutes. Yes. My lord.
To mention recalling application.
Application, yes.
Milord, this is a single bench matter, Milord.
Single bench matter. Then seek the leave of my lord, brother first.
My lord, kindly.
You have to do that everywhere.
My lord.
Singly, hand over.
It has already been released from my lord Justice Bhattacharya. Order is annexed.
To be mentioned. My lord, order.
This matter has not been listed yet. The appeal was filed.
What is the matter? Application? What is it? An application? Hearing matter we are not taking, ma'am. Hearing of appeal we are not taking now. My lord, we are not NOT. Order 4111, my lord, yes. Okay.
Your lordship, there were some suggested corrections in your order dated 1st
Yes.
May. Your
To
lordship,
be
I
mentioned.
submitted the.
Correction of our order.
Yes, your
It
lordship.
will appear as to be mentioned, right? To be mentioned at the top.
Your lordship, it was submitted yesterday as well, and before the vacation also we have mentioned it several times, but your lordship, it has not.
Several
been
times, why is it not coming? They can enter. Several times mentioned. It's correction of our order. This,
This is the.
ma'am, it's correction of our order. This bench.
Yes, yes, your lordship.
This bench.
Yes, your lordship, it was given by a single bench, your lordship.
Give a mentioning slip, please,
Yes.
proper.
The mentioning slip is not with me today. I had mentioned it yesterday, your lordship.
ওনাকে একটা খালি স্লিপ দিয়ে দিন।
Yes, sir.
এটা কথা বুঝতে এত টাইম লাগে। ওদিকে কিছু স্লিপ রেখে দেবেন, ওদিকে কিছু স্লিপ রেখে দেবেন।
Thank you.
ওদিকে স্লিপ নেই কেন? এরকম সাইজের কেন দিচ্ছেন? এখন কি ফুল স্ক্যাপে হয়? কেটে রেডি করে রেখে দেবেন। ঠিক আছে, পরের দিন রেখে দেবেন, কল করুন।
Your lordship, kindly listen. Thank you, lordship.
Appear for the appellant, my lord. There was a direction to submit the cost of administrative notice by 13th of May. I have
Deposited
submitted
out
on
of time.
14th.
Will accept that? Only for that. The postal cost along with written up notice forms which have been filed beyond time is accepted on condonation of the delay in late deposit of the same. First of let the office take steps accordingly.
I'm extremely grateful.
Thank you.
The matter is made returnable.
Pardon?
The matter is made returnable on one.
Why should it be returnable?
Since the administrative notice was prior it was issued, the report could not come. Even this time.
Whenever a report comes, they'll place it. No returnable date is required. Yes.
I'm grateful, my lord.
My lord, this appeal has been argued by us exhaustively.
Yes, they want to. Yes, Mr. Ali, what is your
Yes,
new
I
judgment?
wanted to-
Only for that.
Yes, only for that, Lordship. Yeah, please, one judgment. Only on the point, whatever the inquiry officer, yes, 2010 to SCC 772. For the proposition that whatever document the inquiry officer has Lordship, that has to be
Copy
given
should be given to the.
to a copy. Lordship, that paragraph 21, Lordship will take. Although this is with respect to charge sheet. But I want to say even for jurisdiction, that goes to the root of the matter.
Regarding that number 49 minute 49th meeting not being
48,
given.
49th meeting.
48, 49 not
Lordship.
being.
Paragraph 21, copies of documents which form the foundation of charge sheet against the respondent has been denied to the respondent on lame excuse as projected in the pleadings of the appellant at different stages before the High Court as well as this court, that the respondent at the relevant time was posted in the same division and the documents could have been received by him and reply could have been given. According to the appellant, all the documents concerned were with the division in which the petitioner was posted as executive engineer. In the counter affidavit filed in the High Court, it is specifically mentioned that the documents pertain to the same division in which the respondent has been posted as executive engineer. Therefore, he being in knowledge and custody of the said documents, there was no requirement for the documents to be supplied to the respondent. The very same submission has been reiterated before us by the learned counsel. Further, in our opinion, the submission is without any basis, as the respondent has been suspended on 5th February 2001. Even if the respondent had continued in the same department, it would not have been possible for him to take custody of the documents. Lordship, this is what I want to rely on. That the custody of the documents, the physical document, inspection alone won't do. Custody of the documents, as he would no longer
So
be
where
in
is
charge.
given an inspection here?
Lordship, they said, Lordship, in the minutes it was recorded that
you attended,
only
you
if
could have.
you come, I shall show you the document.
Yes.
Lordship, that is why, Lordship, I could not take any legal advice because of this thing. Lordship, that is why, my lord, if Lordship is not with me, Lordship, I'm praying that I should be put back, Lordship, before the inquiry officer. Lordship, status quo ante, my lord. That
Yes,
is
Mr. Banerjee, what is your answer?
Lordship, before I answer, I will say they proceeded with a fact. Then I have shown that this was kept in a record. Then we have also given him a chance to cross-examine, which he has not done. Lordship, with regard to this judgment, there is no quarrel on the proposition of law. Now, distinguishing factor in this judgment and in my judgment is para 28. I will be placing two paragraphs, para 28 and para 33. Lordship, what happened there? They neither supplied the document nor the document was placed in by way of a examination in chief or cross. But in my case, Lordship, there was a examination in chief and then 165 by the judge. Lordship, kindly come to para 28. An inquiry officer acting a quasi-judicial authority is in position of an independent adjudicator. He is not supposed to be representative of the department, which is not, we have not done here. This function is to examine the exam presented by the department, even in absence of the delinquent official, to see as to whether the unrebutted evidence is sufficient to hold the charges are proved. In the present case, the aforesaid procedure has not been observed since no oral evidence has been examined. The document has not been proved and could not have been taken into consideration to conclude the charges and have been proved against this. So, Lordship, what my learned friend has argued, that handing over is required. No, the key paragraph is para 28. Before taking of those documents into custody and to weigh those evidentiary value, there has to come by a way of an evidence. And Lordship, in my case, there was a procedure. He said that I will observe natural justice. So he made a procedure that you have to prove your case. You have to give your deposition as well. So deposition was taken. Now, Lordship, kindly turn to page para 33.
Yes.
As noticed earlier in the present case, not only the respondent has been denied access to the document sought to be relied. So, Lordship, now para 33, access to the document in my case is given, sought to be relied against him. But he has been condemned unheard as the inquiry officer failed to fix any date for conduct of the inquiry. Pause here for a moment. Lordship, I have shown that I have given him notice. He came to me. I assured him that everything will be followed. So, Lordship, this 33 takes care of what he said, that only inspection is not given. So, Lordship, inspection is given. Lordship, date is fixed prior to. He appeared before me. I took his point. I cross-examined. I look into the document, and those documents, even in an ad interim appeal stage, is before your Lordship. In support, in other words, not a single witness has been examined in support of the charge level against the respondent. The High Court, therefore, has rightly observed that the entire proceeding are vitiated have been conducted in a complete violation of principle of natural justice and total disregard to fair play. The respondent never had any opportunity at any stage of the proceeding to offer an explanation against the allegation made in the charge sheet, which is completely not in my case.
Good.
Now, Lordship, kindly turn to
Yes, which part?
para 25. That's the factual distinction. I have shown my case from para 28 and 33, and then the factual distinction.
Yes.
A bare perusal of 25. A bare perusal of the charges shows that the three charges are based on official document, official communication. We have earlier noticed the relentless effort made by the respondent to secure copy of the document which was sought to be relied upon to prove the charges. These were denied by the department in flagrant disregard to the mandate such and such. So this document was never denied to. He said, please come, see, examine. And then for cross-examination, there was adjournment. So this paragraph is where they did not allow inspection. Here, everything was done, Lordship, and then distinguishing paragraph is para 28 and 33. Now, Lordship, kindly see his written notes of argument. I should not make this comment. His written notes of argument, now he has taken a point of certain biasness, which he has not taken in Can 2.
When verbally arguing, Mr. Ali had argued. Bias had not been.
No, Lordship, I repeatedly said.
Bias of the second, the judicial officer.
Yes, yes. He has not taken that in Can 2.
That has been put in the notes.
If your Lordship kindly.
Was that portion?
Cannot be.
Lordship kindly
Cannot
see
be.
that.
He never argued that.
If your Lordship kindly see. Para page 7, violation of natural justice.
This is what I argued right now. The documents were not given.
This is not allegation of bias.
Then
This is the audio alternative party or natural justice violated. Not bias. He has not taken bias.
I have not argued.
Then
I have
kindly come
did a
down.
single thing which I have not
No,
argued.
no, this is not bias.
And para 9, Lordship.
That was the response number 3.
Lordship. That's it.
This is too
Lordship.
much now.
Lordship.
Response number 3 is the DG. I have been all throughout saying that.
Sorry, Ali. Sorry, Ali.
No, Mr. Banerjee. you are
Lordship, I'm
Wrong
not
there.
taking that.
Wrong there.
I'm not.
We are concluding hearing.
Yes.
Learned counsel appearing for the appellant relies on an additional judgment reported at 2010 to SCC 772, to which learned counsel for the respondents replies. Full stop. Accordingly, hearing is concluded and judgment is reserved in the matter.
I'm
Thank
deeply
you.
obliged.
Thank you very much.
Deeply.
Next.
It was a pleasant. It was so pleasant that Lordships has heard us at length.
No, why? Absolutely. We are here to do that only.
I appear for the petitioner.
Lordship, item number 3, Lordship, I'm praying for not this week.
No, in assigned matter, we have decided not to grant
Lordship,
time
may I?
because repeatedly mentioned by several people, assigned matters are not taking up,
Lordship-
assigned matters are not being taken up. We are taking up assigned matters today. Don't miss the chance.
Lordship, may I?
You are not
Lordship,
granting time.
Lordship, may I? Lordship, I'm on behalf of the state, Lordship. I'm being led by Advocate
Sorry.
Abhishek Prasad.
Whoever
Lordship.
you are appearing
Yes,
for,
Lordship, we have just received the brief yesterday, Lordship.
Sorry,
At least
that's your
some
problem.
time, Lordship.
that's the state's problem. It has been, it is pending since long. This is a matter of 2010. If you have received the brief
Just yesterday, Lordship.
yesterday, that's the state's problem, not our problem or his problem.
Lordship,
Sorry, it states if the state is negligent, we can't do anything. We'll hear out the matter. What is the matter about, Mr. Ali?
This is with respect to the recruitment process of a constable. Lordship, during arguments, Lordship, why this has been assigned before your Lordship, because of order dated September 27, 2021. When it was argued, Lordship, this is with respect to their, the allegation is that I had suppressed about the criminal antecedents. Lordship, firstly, Lordship, I have been acquitted. Number two, Lordship, whether there was any criminal proceeding pending against me, that was ought to have been disclosed. That is the allegation. Lordship, however, when the form was taken by Lordships, then it was seen that the form only said that whether you have been convicted of any criminal proceedings, to which the petitioner has truthfully said, no, he has not been convicted. Thereafter, Lordship passed that order. After partial hearing of the matter, it transpires that the fact as to whether the petitioner had been arrested, detained, or convicted at the juncture when the petitioner made his first application for joining service is germane to the subject matter of dispute. Learned government pleader seeks a week's adjournment to take appropriate instructions and satisfy the court on such score. Accordingly, let the matter stand adjourned and file a supplementary affidavit. Lordship, that supplementary affidavit has been filed. It is admitted that he was not detained, arrested, or convicted of any offense. But they say that I ought to have disclosed about the pendency. Lordship, that unfortunately, Lordship, it's a form.
What was the stage of the criminal proceeding? Charge sheet has been filed at that point of time?
Lordship, no, my lord. In 2001, Lordship, at that point of time.
No, when you filled up the form.
That, Lordship,
you're not sure.
I'm not sure. But in 2001, Lordship, I have been acquitted.
Please show us the form.
Lordship, kindly takes the affidavit in opposition, where the form was annexed. Page 16 of the affidavit of opposition.
Let us find out the affidavit in opposition first.
Lordship.
Lordship, may I pray for one prayer only, Lordship?
What prayer?
Lordship, may kindly keep it as a Passover matter, Lordship, then. Since I am led by Advocate Abhishek Prasad, Lordship, may kindly keep it as a Passover. Only
no,
since you are led by Mr. Prasad, there should be a Passover. Mr. Prasad is special.
No, Lordship, just because I have been received instruction.
You are also on the state panel.
No, Lordship.
But the backsheet is of Mr. Abhishek Prasad. How can he receive it yesterday?
Lordship.
Yes, Mr. Prasad, we are told that you received the brief yesterday. It's your backsheet.
No, my lord, the brief was misplaced. My clerk has find it out today itself. My lord, if my lord really want to hear the matter, my lord, I can.
Fantastic. Thank you. Affidavit in opposition.
Lordship.
Let's find out that. Opposition patient. Last day.
It's a very thin bunch, my lord.
Haja type.
The backsheet of Manoj Kumar Sadhu.
Yes, thank you. Thank you. Got it. এটা সব পাতা খুলে এসেছে. Yes. You attend retirement age now?
No, man.
Thank God. Yes.
Page 16.
16, yes.
At 17. 16 the form starts. And at 17 is the relevant column. Have 13, my lord. Have you ever been arrested, detained, or convicted by court of any offense? If the answer is yes, the full particulars of the arrest or detention or conviction.
You are not convicted, we understand. You are not even arrested or detained.
No. And that is the supplementary affidavit is that.
Your supplementary affidavit.
Their supplementary affidavit.
Oh,
they have filed supplementary affidavit.
This was the question asked at it.
Lordship. Lordship directed them to file their supplementary affidavit. The answer is no. Lordship, this is a truthful answer. Lordship, there is no doubt about it.
On affidavit, they should be truthful at least.
Lordship?
On affidavit, at least they should be, generally, people should be truthful. There are exceptions.
They have accepted, my lord. That
obviously, they're the state, they should be at least have some neutrality. So this was the only ground. Show us the ground now in your dismissal order. You are dismissed.
My lord, he was a participant. And my lord, at the very outset, as there was a criminal antecedent, he was accused of a 498A case, 302 case.
Prasad, where in the form is that to be disclosed?
My lord,
he was dismissed for non-disclosure.
No, my lord, he was never not appointed yet.
Not appointed because of this non-disclosure suppression of
we have found him unsuitable because of his criminal antecedent. My lord, we have kindly consider the supplementary. My lord,
No, let us first see
Here.
your decision to. Oh, there was no decision, obviously.
No,
He
my
was
lord,
not taken.
the decision is Maloti Malul see there is a stamp in the VR.
Mr. Ali, should we directly go to him? Because this is the point.
Lordship,
involved.
this is a short point.
Short point, my lord,
Requested, let Mr. Prasad say, then he will give your answer.
if Maloti will see the VR, Maloti,
We'll take up the supplementary affidavit, Mr. Prasad.
Malota supplementary affidavit is affirmed on,
Just let us find out that.
that is on October 2021.
Yes. Got it.
And before that, my lord, kindly consider the VR ones that is annexed in the opposition of the state, my lord.
That's what
Which page?
Page 16.
the one I showed, madam.
16 years.
My lord, there is a stamp.
Unsuitable stamp we have seen.
Yes, my lord, that is the only, my lord, that is the short ground on which, my lord, we have found him unsuitable. And the ground is, my lord, elaborately mentioned in the supplementary affidavit.
Mr. Prasad, the Indian law is that one should be presumed to be innocent unless proved guilty. So why should we be honest? Then I can just file whenever my enemy, I have some enmity with someone, and I just lodge a diary and an FIR, put in a non-cognizable offense or cognizable offense, and then he will be unsuitable for the job. Why?
My lord, only
He
one
was
thing,
subsequently acquitted, even not even acquitted. I mean, the case was dropped.
the case was dropped because of, my lord,
498 at the drop of a hat, we can,
my lord,
anybody can.
498, there are other charges. My lord, there is a
Whatever
three-
charges,
three
whatever
zero
are the charges, Mr.
Yes.
Prasad, for that, why should one be considered? Yes, we understand. This is a job of a constable,
Yes, my lord, police.
police constable. So for that, we understand that it would be very,
Impeccable character.
yes, impeccable character has to be there. But my character does not become peccable if somebody just lodges a diary and a case is initiated.
My lord,
Anybody can then, if a vindictive wife wants to put somebody out of job or prevent somebody from getting, why a vindictive wife? Anybody and everybody can come up. My neighbor can come up and lodge
yes,
a
my
diary.
lord, I fully understand.
This should
but
not be a ground of
my lord,
unsuitability.
only one thing that I want to point out. My lord,
And one other aspect, Mr. Prasad, by now he has been discharged also.
my lord, there is no
So
quarrel
therefore,
to
we
that.
can take judicial notice of that also, and we can direct you to.
And my lord, why my lord, comment of unsuitable was given. My lord, our rule says so.
Which was that?
Kindly. My lord, if my lord will consider the supplementary.
Yes, supplementary.
My lord, I am showing the averment page, paragraph 3. 3 is the gist of the issue. And my lord, the corresponding, my lord, rule is there at page 9. I will show to that also.
Your page 4, 3B says a candidate with a record of past criminal activities.
Yes.
So he did not have any past criminal activity.
Activities made because he was a my lord, implicated in a case. There
That
was
is
a
not
criminal.
his criminal activity. You lodge a diary against me, right? Case is initiated. Where is my criminal activity?
My lord,
In suffering a diary and a criminal case. There is no criminal activity on my part.
my lord, subject to correction, my lord, there was a specific.
One will never get a
Allegation.
chance in any defense force or any.
My lord, I am understood.
Yes, if you join the service, then if there is something, you can have a disciplinary inquiry, definitely.
Yes.
Whether there is some, you can independently also decide without
Yes,
without a
If there
conviction.
is a suppression, we can terminate also.
Yes, you can.
My lord, if my lord will consider the
Let us see that rule.
rule,
You are speaking of some rule.
page 9, my lord, kindly consider.
Page 9. Yes,
My lord, may I read out?
please. The relevant portion you can read out.
Yes, my lord, I'm reading the relevant portion. Instruction relating to verification of character and antecedent of candidates seeking employment under the government of West Bengal as contained in Department Memo such and such, dated such and such, uh, since been reviewed by this government, and it has been decided that verification of antecedent of candidates should be made invariably before making appointment to both permanent and temporary posts in both superior and inferior services under the state government and in any state government undertaking or organization wholly or partially owned by state government. Second, my lord, a candidate with a record of past criminal activities may be declared unsuitable for employment under the state government or in any state government undertaking organization, but no candidate shall be considered unsuitable for employment under the state government or in any state government undertaking organization by reason only of the fact that he is or was a member or is or was associated or connected with the activities of any political party, group, organization prior to his appointment. Once verification of an antecedent of an employee has been made at the time of his initial appointment under the state government or in any state government undertaking organization, no fresh verification of antecedent of the employee will be required when his
So this is the only thing, past criminal activity.
past criminal activity, that is, my lord, that the clause number 2, that is the only issue on the basis of which, my lord, we have decided that as there is a, my lord, it is a matter of record.
Mr. Prasad, tell us,
Yes.
what was his criminal activity? His criminal activity. Activity there has to be, it has to be positive act, not a negative passive act. Passive act can also be criminal, but tell us what was his criminal activity.
My lord, I should be frank.
His wife lodged a complaint.
Lodged-
A case was initiated under section
Lord,
498A.
My lord, the father of the wife had lost the complaint because she
Even the
died.
wife had not complained.
She died. She died.
Very well. Father of a deceased lady
Hmm.
may definitely, that will be the knee-jerk reaction, Mr. Prasad.
Hmm.
Will first go and lodge a 498A in general cases. We have seen this in criminal matters. You know that.
Hmm.
The first thing a father first person the father will suspect is the husband.
Yes.
In most cases, unless there is a very good relation or something
Yes,
superlative.
yes.
So that was done. But what was his criminal activity? Apart, we are forgetting that subsequently he has been acquitted and all these things.
Mhm.
What was his criminal activity? Tell us.
My lord, that is-
Having a complaint lodged against himself.
No, my lord, I should be frank, my lord, the criminal activity that they are try to point out that there is a involvement
This
in-
will be risky, Mr. Prasad. We are saying this because then anybody can prevent anybody from getting a government job just by going and lodging a serious complaint. And later on, he's acquitted, and
Yes.
so his opportunity is gone.
And another issue, my lord,
What happened to that criminal case?
my lord, that has
Acquitted.
been, my lord, the person was acquitted because prosecution had failed to, my lord, substantiate the complaint. It was a benefit of doubt. It can be said it is a benefit of doubt. My lord, and another issue, my lord, we have considered because the impeccable character police force, that is the another issue.
Mr. Prasad, tomorrow if my wife goes and
Yes, my lord,
lodges
I
a complaint
can-
against me,
My lord, quarrel with,
otherwise I may have impeccable character.
yes.
But once somebody lodges a diary complaint against me, one may have a quarrel with somebody, and the knee-jerk reaction, the first reaction, and here the lady died. Obviously, it was very serious.
Yes. And
But I mean,
the father had implicated the husband and the in-laws in the death of the,
obviously,
yes.
any father would,
Yes,
many
my
many
lord,
fathers at
that
least
is
would do
there,
that.
but he was acquitted. He was acquitted. With the observation is that the prosecution did not able to substantiate.
That is the observation in all cases, obviously.
Yes.
That does not automatically mean that
Yes, my
the
lord,
prosecution was,
what is following
because
from you?
was there any caustic remark that prosecution failed to do its duty or something like that? Even then, Mr. Prasad, actually,
My lord, I cannot improve over the record. He has been acquitted. And my lord, the tribunal had also, my lord, considered this fact of my lord, criminal antecedent, and on that basis, my lord, tribunal has rejected his application, and my lord, thereafter he has come. Tribunal order is also, because the tribunal is of the view that the employer is having that discretion to consider. And my lord, to that effect, we are having, my lord, Honorable Supreme Court has also,
employer definitely has the discretion. Definitely has the discretion. But it has to be reasonable,
reasonable.
and it is justiciable always before a court of
Yes.
law. I mean, discretion is definitely there, but that discretion has to be read in, I mean, in proper perspective.
Yes, my lord, I cannot argue
It
on
cannot,
this
that
issue.
discussion cannot be exercised against criminal jurisprudence in India. I mean, in many countries, in fact. So where is the order of the tribunal?
My lord, it is there.
Which page of the
I will
petition?
kindly consider.
66.
My lord, it is after page 66.
66, man.
Acha, criminal antecedents, where is that language? That we did not find. Criminal activities.
But that is criminal. What is incorporated is criminal activities in our
Clause two.
circular.
In your this departmental
Mhm.
circular, yes.
My lord, to consider the VR. Criminal activities is the my lord, issue that we need to look into.
Clause 1 is about antecedents, which shall be
Yes.
verified. And clause 2 says
68
that if criminal activities are found, he should be declared unsuitable.
Antecedent is also there. Clause 1, my learned friend has right.
Yes, yes, let us see that.
It's verification.
Antecedent is where?
My lord, the clause 1 of the memo itself.
Oh, yes, verification.
Verification of antecedent of candidate. One antecedent.
Yes, no other antecedent has been, I mean,
Yes,
cited
my
by
lord, here the only adjective is criminal.
antecedents. Definitely you can consider, and you can also consider whether there were past criminal activities. But those had to be criminal activities by him. To say that it was criminal activity, that had to be proved beyond doubt. Suppose previously he was convicted,
Yes,
even
my
for a
lord,
theft, pilferage, then also he cannot become a police constable.
that is there.
You're passing on judgment.
And my lord, another issue that I want to point out, my lord, now as of now he is 51 years of age. Then my lord, it is very difficult to, because he has to undergo a training, strenuous training.
What is the retirement age?
My lord, 60, not
60. 60.
Yes.
And what is the age of, I mean, upper age of applying?
32.
But then we'll give him leave to seek compensation.
My lord, I am leaving to your lordship. I am leaving to, cannot.
No, Mr. Ali, your client has to undergo a physical test now, because practically speaking, if you join the police force, you have to be physically agile still.
Lordship.
Only that. Only that. But here he was shut out at the outset.
The outset,
There's a
and
difficult.
I was immediately.
My lord, we are, my lord, we are under impression that, my lord, this is a serious issue.
Yes, compensation, probably it was not your fault also, because the tribunal affirmed your view. Compensation, Mr. Ali, we are not giving leave, because compensation, this is not such a gross error, or any malice is not there in the, we don't find any malafidis on their part in rejecting it. It was one of the interpretations, possible interpretations.
Actually, the training, Lordship, for any. There are a lot of
Strenuous training, my lord.
strenuous training for a constable, my lord. I don't think so.
It has to be, my lord. What I have been instructed, my lord, that is the requirement. That is the requirement. They have to undergo a training.
He will have to do all that.
My lord, I am
Achha,
leaving to you.
the constables do not, after they join the service, they don't have any regular.
Yes.
That is also there. There must be there. It's not so rigorous.
Yes. But promotion.
But don't do this after taking him, put him under so much rigorous training.
No,
Don't be biased on that.
no,
So that he fails deliberately.
what everybody is my lord, following with regard to constable, he has to follow that also. My lord, 1 year I have been instructed 1 year is the training.
1 year. No, he will undergo. He will have to undergo everything.
Yes, we shall undergo training.
But our general experience says that after one is admitted to the post of constable, their physics don't show any sign of training.
Sign of training.
This will be an exception. Let us have one fit constable at 51.
My lord, if my lord will allow
Pass
me,
the physical training, everything at the time of getting his employment.
my lord, only one judgment of the Honorable
Long
Supreme
jump,
Court. If my lord
Yes,
will
cite
permit
it.
me.
Cite it. Absolutely. You complete your arguments. We are not shutting you out. ওই যেটা দিয়েছেন। 2013-7?
Malot 1996 11 SSC 605, which the tribunal has also related.
আচ্ছা, show us that.
Malot, I'm
এটা অন্য। This is on the discretion of the authority.
Malot, yes, Malot, that
We don't doubt there is a discretion of the authority, but that has to be exercised
reasonably.
reasonably.
It is a short judge order, Malot. Malot, may I please?
Let us see what was the basis here. Yes. There it was the other way around. The tribunal held what we are holding.
তিলকরাজটা বের করো। তিলকরাজ আপনি বের করে দিন তো। হ্যাঁ।
What are these sections, Mr. Prasad? This
Malot,
304. 304 is culpable homicide.
yes. Malot, in case of the petitioner, Malot, petitioner
Must have been 30,
yes,
302
Malot,
also,
that is there.
because the lady
It
died.
was 306. It was abatement to suicide.
Abatement of suicide.
498A 306.
198 and 306 in your case.
Lordship.
498 and 306.
Yes, Mr. Prasad. Any other judgment?
Malot, another Malot.
বলো।
কোনো দরকার নেই ওটা ছিল।
Yes.
দেখি পাত্র সাহিত্যটা বের কর। Malot, paragraph 16,
16 years.
15 onwards.
In fact, you can also today change your form to include pendency of criminal proceeding.
I think they have
That
done.
was there.
I think that has been done.
Here to change হয়েছে না? Here এটা ঢুকেছে antecedent এর ইয়েটা
Pendency of criminal proceeding.
Because you cannot do that because, I mean, one is innocent unless proved guilty.
otherwise it will be challenged.
That will be struck down. And you can only hope it does not come before a bad code like for this.
No.
No, but this is, I mean, we are more on a little bit on human rights also. I mean, to right to live, to get a job,
Yes, ma'am.
proper job.
There should be a
And
balance.
police force is a hallowed job. I
Yes.
mean, it's a respectable job. I'm a police constable in the locality. Unless you misuse it, it's absolutely a respected job.
And Malot, balancing all this right, Malot, Supreme Court has said also that police
Yes, apparently the Supreme Court judgments are against what we are saying, but we'll have to overcome this.
No, these are the two judgment I am
These are very good judgments you are citing.
heavily relying upon.
জাস্টিস কুমার এটাতে আমি চেক করছি এটাতে আপনি যদি ডিফার করেন তাহলে কোর্টে চলে যান পরে আপনি যাইতে চিন্তা করেন না আপনি চিন্তা করবেন যদি মনে করেন আই উইল ডিফার আপনার জাজমেন্টটা আপনি পরে দিতে পারেন তারপরে আমরা আপনি একটু দেখে নিন চিন্তা করে নিন আপনি চিন্তা ইফ ইউ ওয়ান্ট টু ডিফার তাহলে কোর্টে বলে দেবেন যে দেখেন no the present challenge has been preferred
And Malo, this is our High Court. This is the last one.
যতবার দিতে
am
যাচ্ছি
citing.
ততবার সাজা
All judgments.
Mr. Prasad, conclude once and for all. Every time we are
No,
going to
sorry,
pass a
but I am
judgment,
extremely sorry.
cannot
This
be
is the last
inspired.
one. This is the I
We
will
have-
not cite it.
we are also human beings. We have to mold our mind because we are
Yes, Malota.
before
then,
passing a
Malota, I am
judgment,
taking it
deciding
back.
the
I am taking it back.
no, not
Malota,
that,
sorry.
not that. Yes, Mr. Kolwell was won or lost.
Malota, he is for the petition.
He lost.
Malota, we own, state own in this.
Then we will look into it. Yes. Yes. Which paragraph?
Malota, paragraph 7.
We don't have the exact color. That's why we are using yellow for respondents. Yes, we are afraid. Please place it.
Malota, we are afraid that Malota, paragraph 7 I am reading.
7. Yes.
We are afraid that the judgment relied upon is of no help to the petitioner as there is material difference between the two cases. In our case in hand, the petitioner was a candidate to be appointed in the police service, whereas in the decision cited, the lead petitioner was appointed as a commission agent in the railway. In Meher Singh case reported in such and such, the Apex Court held that the candidate to be recruited to police must be worthy of confidence, of utmost rectitude, and must have impeccable character and integrity. A person having criminal antecedent would not fit into that said category. One is likely to erode credibility of police ought not to enter police force. Even he is acquitted or discharged in the criminal case, that acquittal or discharge order will have to be examined to see whether he has been completely exonerated in the case, because even a possibility of his taking to the life of crime poses a threat to the discipline of the police force. In this context, we may pertinently refer to the case of Sushil Kumar reported in successor, wherein the respondent had appeared for recruitment as a constable in Delhi police services. He was selected provisionally, but his selection was subject to verification of character and antecedent by the local police. On verification, it was found that his antecedent were such that his appointment to the post of constable was not found desirable. Accordingly, his name was rejected. He approached the tribunal. The tribunal allowed the application on ground that since the respondent had been acquitted of the offences punishable under 302(3)(24), read with section 34 of the IPC, he cannot be denied appointment. The Honorable Supreme Court have disapproved the tribunal view and observed that verification of character and antecedent is one of the important criteria to test whether the selected candidate is suitable for the post under the state. The Apex Court further observed that though the candidate was provisionally selected, the appointing authority found it not desirable to appoint him on account of his antecedent record, and this view taken by the appointing authority in the background of the case cannot be said to be unwarranted. Whether the respondent was discharged or acquitted of the criminal offences, the same has nothing to do with the question as to whether he should be appointed to the post. What would be relevant is the conduct or character of the candidate to be appointed to a post and not the actual result thereof. Therefore, the judgment cited on behalf of the petitioner is clearly distinguished on facts from our case in hand. This is the paragraph that I am relying.
Mr. Prasad, do you have anything else apart from his?
No, ma'am. This is the
Does your IB inquiry or whatever inquiry reveal any other thing?
My lord, no.
In your affidavit, you have not disclosed
No,
any
no,
other
no,
thing.
we
The
have
pendency of that case.
Yes, supplementary we are categorical. This is the ground. Because of that involvement of the criminal case, my lord, we have found him unsuitable.
Yes. Great. So you are passing our judgment.
Yes, ma'am.
The present challenge has been preferred by the petitioner, who was a candidate for recruitment for provisional selection as a constable in the police forces of the state. Full stop. By the impugned judgment, the learned tribunal dismissed the challenge of the petitioner to the refusal of the respondent authorities to accept the petitioner as a suitable candidate for the said post at the outset. Full stop. In the form which was filled up and submitted for such purpose by the petitioner, the respondent authorities put a stamp double inverted মধ্যে পুরো ব্লকে unsuitable double inverted close. Full stop. Next para. The reasons cited by the respondent authorities for doing so is that a criminal case under sections 498 capital A and 306 of the Indian Penal Code within bracket then prevalent bracket closed was pending against the petitioner at the relevant juncture. Full stop. Next para. Learned counsel for the appellant argues that the selection form required disclosure only as to whether the applicant had been arrested, detained or convicted by the court of any offense, to which he answered within double inverted no, double inverted close, full stop. Next para. It is contended that merely being incriminated in a criminal case on the basis of a complaint of a person cannot tantamount to be arrested, detained or convicted, unless there is an actual conviction by a criminal court. Full stop. Next para. Learned counsel further argues that ultimately the appellant the petitioner appellant was acquitted in the criminal case, which was also brought to the notice of the tribunal. Full stop. Next para. Learned counsel submits that as such, the rejection of the application of the petitioner appellant was arbitrary and dehors the law. Full stop. Next para. Learned counsel appearing for the state respondent submits that the circular that circular number 1835 hyphen capital P full stop capital S full stop dated August 4, 1977 issued by the Home Department of the government of West Bengal specifies in clause small I within bracket thereof that verification of antecedents of candidates should be made invariably before making appointments to both permanent and temporary posts in both superior and inferior services under the state government and in any state government undertaking or organization wholly or partially owned by the state government. Full stop. Next para. In clause small ii thereof, both of you please take your seats. II thereof, it is provided that a candidate with a record of past criminal activities may be declared unsuitable for employment under the state government or any such undertaking organization. Full stop. Next para. Learned counsel submits that the discretion lies with the employer as to which candidate is suitable and who is not. Full stop. it is, thus, submitted that the tribunal was justified in turning down the challenge of the petitioner and the present challenge ought also to be dismissed. Full stop, next para. In support of his contentions, learned counsel appearing for the state cites নামটা দিয়ে দেবে আমি সাইটেশনটা শুধু বলি reported at 1996 11 SCC 605 where the Supreme Court observed that the tribunal therein had allowed the application on the ground that since the respondent had been discharged and stroke or acquitted of the offense punishable under section 304 IPC, section 324 read with section 34 IPC and under section 324 IPC, he cannot be denied the right of appointment to the post under the state, full stop. While reversing such conclusion, it was observed by the Supreme Court that verification of the character and antecedents is one of the important criteria to test whether the selected candidate is suitable to a post under the state. Full stop. Though the candidate in the said case was found physically fit and passed the written state and interview and was provisionally selected, it was held that on account of his antecedent record, the appointing authority found it not desirable to appoint a person of such record as a constable to the disciplined force. Full stop. The Supreme Court further observed that the view taken by the appointing authority in the background of the case cannot be said to be unwarranted and observed further that what would be relevant is the conduct or character of the candidate to be appointed to a service and not the actual result of a criminal case. Full stop. Next para. Learned counsel for the state next cites such and such reported at 2014 3 SCC 145. Full stop. In the said judgment, the Supreme Court internally observed that it was unfortunate that the respondent was facing an inquiry at the time when he was selected in pursuance of the process of selection. Full stop. At the time when the respondent had applied for an appointment to the post in question, though he was found eligible, he could not be appointed as he was facing a CBI inquiry. Full stop. It was observed that the respondent, in the circumstances, was rightly not appointed to the post in question, and he could not make any grievance on the ground that he was wrongly denied appointment to the post in question, because in fact he was facing a CBI inquiry at the relevant time. Full stop. Next para. The Supreme Court further went on to observe that it was true that the respondent therein was given a clean chit by an order of the CBI court subsequently, but by that time the entire process initiated in pursuance of the advertisement in question for appointment to the post had come to an end. Full stop. Nothing with regard to appointment to the post was kept pending at the time when the next advertisement for appointment to the post had been published. Full stop. It was observed further that it is unfortunate that the respondent did not apply again for the post in question, and had he applied for the post in question and he been given a clean chit by the CBI court at the time when his case could have been considered, he might have been appointed to the post in question if he had been found to be the best among all the candidates who had applied for the post in question. Full stop. It was observed that unfortunately, this had not happened, and therefore the respondent cannot have any right to be appointed to the post in question at the relevant juncture. Full stop. Next para. Learned Counsel for the respondent next cites an unreported division bench judgment of this court in WPST 106 of 2010 within bracket Partho Sarathi Sinha versus the state of West Bengal and others, where the coordinate bench relied on Mehar Mehar Singh apostrophe S case reported at 2013 7 SCC 685, where the apex court held that a candidate to be recruited to police service must be worthy of confidence, of utmost rectitude, and must have impeccable character and integrity. A person having criminal antecedents would not fit into the said category. It was held, even if he is acquitted or discharged in the criminal case, that acquittal or discharge order will have to be examined to see whether he had been completely exonerated in the case, because even a possibility of his taking to the life of crimes poses a threat to the discipline of the police force. The antecedents, in the said case, were held to be such that his appointment to the post of constable was not found desirable. Next para. Upon a careful perusal of the said judgments, we find that the ratio laid down therein is not squarely applicable to the present case. Next para. Considering the application form within bracket verification role in the instant case, we find that the only deterrent to giving the appointment to the petitioner was in clause 13 of the said role. Clause 13 provided, clause 13 posed a question as to whether the candidate had ever been double inverted arrested, detained or convicted by court of any offense, double inverted clause. Next para. It is an admitted position that at that point of time, although a criminal case was pending on the basis of a complaint lodged by the then deceased wife of by the father of the then deceased wife of the petitioner, there was no instance of arrest, detention, let alone conviction of the petitioner. Next para. The respondent state also cites a circular dated August 4, 1977, issued by the Home Department of the Government of West Bengal. A careful perusal of the same shows that in clause small I thereof, there is a provision for verification of double inverted antecedents of candidates before making appointments. In the present case, however, apart from the pendency of the criminal case at the relevant juncture, over which the petitioner himself had no control, has been cited as antecedents of such nature that the candidature could not be considered. Next para. However, to come within the purview of double inverted with the antecedents, double inverted clause, there had to be a positive or passive act of the petitioner which would speak against the morality, ethics, character or integrity of the petitioner otherwise. Next para. Here, not a single instance of such nature has been cited. Next para. If the proposition for rejection, proposition advanced by the respondents for rejection of the candidature of the petitioner is to be accepted, it also has to be taken that any competent candidate, even of impeccable character and integrity, can be prevented from getting a service either in the police forces or any other state government services merely at the whims and fancies of any person having enmity against him or having a perception of any offense committed by him, comma, by the simple act of lodging a complaint, comma, containing serious allegations of highly punishable offenses, which itself, comma, mandatorily under the law, comma, would cause a first information report to be registered and a criminal proceeding to be initiated. Full stop. Next para. Such proposition cannot be said to be reasonable from any perspective whatsoever. Full stop. A person, comma, without himself or herself doing anything to touch upon her antecedent or character, comma, cannot be impeached or cast blame upon merely by the act of a third party, comma, without it being thoroughly investigated as to whether there is any justification or truth behind such wild allegation. Full stop. Thus, comma, we find that the test of within double inverted antecedents could not be applied to the petitioner per se to reject his candidature. Full stop. Next para. Clause Roman II within bracket of the circular dated August 4, 1977 also comes into play in the present context. Full stop. It provides that a candidate with a record of double inverted mধ্যে past criminal activities, double inverted clause, may be declared unsuitable for employment under the state government or any state government undertaking or organization. Full stop. Next para. Inspecting such criterion closely, comma, we cannot but observe that the expression double inverted mধ্যে criminal activities has to be a positive act done by the candidate in question, comma, which comes within the purview of criminality. Full stop. Next para. To call a past act of a person within double inverted criminal double inverted clause, comma, the person either had to be convicted or even if not convicted in a court of law, had to have faced some punishment at some level to label the person to be criminal. Full stop. Next para. In the present case, comma, the petitioner did not have any hand or control at all in a third person lodging a complaint against him, on the basis of which an FIR was registered and subsequently a criminal proceeding was pending at the relevant juncture. Full stop. We completely fail to understand as to how a person, comma, against whom a complaint has been lodged and the criminal proceeding initiated, comma, could be said to have any activity which is criminal in nature in such complaint being lodged or the criminal proceeding being initiated. Full stop. Next para. Thus, comma, the test of past criminal activities, double inverted mধ্যে past criminal activities, has to be higher than mere allegations being leveled against the person, comma, resulting in the initiation of a criminal proceeding. Full stop. Next para. Insofar as Delhi administration versus Sushil Kumar's case Supra is concerned, comma, the Honorable Supreme Court took into consideration the facts of the case and observed that on account of his antecedent record, comma, the appointing authority found it not desirable to appoint the person of such record as a constable of the disciplined force. Full stop. It was also observed that the view taken by the appointing authority in the background of the case cannot be said to be unwarranted. Full stop. The ingredient which was considered in the judgment, in the said short judgment, was that a criminal proceeding was pending against the person concerned under several sections of the Indian Penal Code. Full stop. However, comma, we do not find a detailed discussion as to whether there was any other antecedent which was considered by the authorities in the said case. Full stop. Next para. In the light of our above discussions, comma, we do not find the decision taken by the Honorable Supreme Court in the said case, in the facts of the said case, to be a binding precedent within the contemplation of Article 141 of the Constitution of India. Full stop. Next para. In Tilak Raj Gandhi's case, Supra, comma, the Supreme Court repeatedly recorded that it was unfortunate that the respondent was facing an inquiry at the relevant time, and since subsequently he was exonerated, comma, if he had applied subsequently when the exoneration took place, comma, he might have been considered for the post in question. Full stop. Next para. Thus, comma, seen in proper perspective, comma, we cannot but find that in the said judgment also the Supreme Court had taken a lenient view. Full stop. Moreover, comma, the conditions which were to be met in the said case to become eligible for the post in question therein, and stroke or the advertisement or application or the clauses thereof are not before us, comma, since those were not discussed at detail in the judgment of the Supreme Court. Full stop. Hence, comma, we cannot enter into a roving inquiry and take the said judgment as a blanket precedent in all such cases for the proposition as sought to be advanced by the respondent. Full stop. Next para. In the coordinate judgment in the matter of Partho Sarathi Sinha, comma, the coordinate bench, the division bench had distinguished between a commission agent in a railway, comma, in which case it was held that a person is not found guilty unless a person is presumed to be innocent unless he is found guilty, and the case where an appointment to a police force was being considered. Full stop. Next para. The division bench took a view that for being recruited to police service, one must be worthy of confidence, comma, utmost rectitude, and must have impeccable character and integrity, and a person having criminal antecedents would not fit into the said category. Full stop. Next para. We have no quarrel with such proposition, comma, more so since the said position is also borne out by the circular dated August 4, 1977, cited by the respondent authorities. Full stop. Next para. However, comma, in the present case, comma, we find, comma, for the reasons given above, comma, that the present petitioner did not have any past criminal activities at all other than the perceived antecedent of pendency of a criminal case against him. Full stop. Next para. Even in the said circular, comma, it may be noted, comma, no distinction is drawn between an appointment to the post of any disciplined forces like the police authorities and between any other posts in any other service of the state government. Full stop. Thus, comma, the distinction drawn in Partho Sarathi Sinha Supra between appointments in a police force and other forces does not apply, at least insofar as the circular dated August 4, 1977 is concerned. Full stop. Next para. What is sauce for the goose is also sauce for the gander. Full stop. Since the tests applied to any other government, state government service does not differ as per the said circular from an appointment to the police forces, comma, at least insofar as the said circular is concerned, comma, we cannot but hold that the deterrence in making appointments regarding past criminal activities or antecedents of the candidates is not applicable in the case of the present petitioner at all. Full stop. Next para. Insofar as clause 13 of the verification rule is concerned, comma, as we have discussed earlier, comma, the petitioner had neither been arrested nor detained nor convicted by any court at the relevant juncture. Full stop. Even subsequently, comma, the petitioner has been acquitted by a competent criminal court of law, and as such, comma, we do not find any reason for the petitioner to petitioner not to be given a chance to join the police forces. Full stop. Next para. We are not unmindful of the position of law and prudence that for appointment to the post of a police constable, or for that matter any disciplined forces, a higher level of moral rectitude and integrity of character is required. Full stop. Next para. However, the character or integrity of a person cannot be said to be dented even in the least merely because a complaint is lodged against him carrying serious allegations of offences pursuant to which a criminal proceeding is merely initiated against him. Full stop. As we have, we reiterate that if such be the case, there would be many suitable candidates having impeccable character and integrity, which would be lost by the disciplined forces merely because a fence sitter or a person having quarrel with the said person lodges a complaint containing allegations of serious offences. Full stop. Next para. In such view of the matter, we are of the opinion that the learned tribunal erred in law and in fact in affirming the decision to reject the candidature of the petitioner to the post of constable in the Calcutta police. Full stop. Next para. We are informed that the petitioner is now about 51 years of age and that the age of retirement is 60.
Yes, yes.
60. Full stop. Next para. Despite keeping in mind the fact that the petitioner has long crossed the age when he could first apply for being appointed to the post of a police constable, since the application was made when the petitioner was so eligible and he was restrained from joining the post due to no fault of his own, and also keeping in mind that there are still 9 years of service left otherwise for the petitioner, we direct the respondent authorities to appoint the petitioner, subject to the necessary physical verifications and tests being taken in respect of the petitioner. Full stop. Such exercise shall be completed within 2 months from the from date. Full stop. Next para. Accordingly, WPST number 541 of 2010 is allowed on contest, thereby setting aside the judgment and award dated March 23, 2010, passed by the West Bengal
State Administrative Tribunal.
Yes.
West Bengal Administrative Tribunal in case number OA 1040 of 2003, in the light of the directions given above. There will be no address to cost.
Your Lordship, may I humbly seek one indulgence, my lord. Appointment is to be prospective, my lord. Can it be mentioned, my lord? I'm leaving to your Lordship.
There's no fault on his part. So
Then let it be what is there, let it be.
we'll keep it, we will leave it vague
Yes, I'm good.
for a further challenge.
Yes, yes. I'm good.
কিন্তু এটা কিন্তু সুপ্রিম কোর্ট গেলে সেট অ্যাসাইড হবে definitely be set aside if it
Yes,
goes up
I know that motion
because this is against the
Motion
grain
and
of the
motion.
Supreme Court judgment. So
It
let
will-
us
it will give
yes.
I'm good.
Supreme Court যাই বলি
Lordships, I appear for the respondents.
This is my appeal, my lord, on section 37 of the Arbitration and Conciliation Act, my lord. Now, my lord, matter was last heard in 2022, my lord. I am only praying for some time, my lord. I need
you have
to
not
arrange-
heard even once, so we are not asking for time.
Only, my lord, one day, my lord, tomorrow, my lord, I'll just arrange the papers and come. my lord.
Assigned matters, several people mentioned, you are being penalized for them. Because that assigned matters are not taken up, we are taking up, we have fixed it and.
People written notes, it will take some time to argue, my lord. This is a.
Lordship, I'm also not standing in the way. I'm also being led by Mr.
Standing in the way of us or him?
Of him, Lordship.
But I'll have people written notes, my lord, and also, my lord, try to argue in the one day itself, my lord. It will take some time.
Will not give you entire one day. What are the points
Not
in
one day, my lord.
Give us an indication of the points.
I'll tell you what had happened, my lord. The contract was for supply of iron ore, my lord. My client is engaged in the mining of iron ore, my lord, and the respondent, my lord, they manufacture pig iron, my lord. My lord, they would have to participate in the tender, my lord. If they are a highest bidder, my lord, then I would supply them iron ore subject to availability, my lord. Now, my lord, this supply was to be made upon 100% of payment of advance.
This 37 is against the section 34.
34, my lord.
Yes, continue, please.
So, my lord, 100% payment of advance, but, my lord, they don't pay it in advance, my lord, hence I don't supply. Taking on this issue, my lord, they invoke the arbitration clause, my lord, on the ground that I have committed breach of the contract, my lord, that because I could not supply, they suffered damages because they had some vendors to supply, they could not supply them. But, my lord, my case is that there is no proof to show, my lord, that some third-party contract was there of which I was never aware of, my lord.
You were
never aware of, my lord. The claim was the awarded claim, my lord, is remote, my lord, I say. Because they had to fulfill some other obligation, they could have purchased the
You take it the
materials
section
also.
73 tests.
Yes, my lord. Section 73 test, and also, my lord, secondly, my lord, there was never any waiver of the contractual terms. This 100% payment, my lord, the arbitrator goes on to hold that there was a waiver, that 100% payment was not required, my lord. That there was never
What
any.
was the basis of arbitrator holding that?
Basis, my lord, he holds, my lord, based on the pleadings, my lord. There is no written agreement, my lord. There is no proof of any novation or alteration of the contract, my lord. The arbitrator holds on pleadings because the case of the claimant was.
It was affirmed in 34.
Affirmed in 34, my lord.
What is the logic? Any additional logic?
No additional logic, my lord. It only, my lord, several judgments are quoted, my lord, and the same logic is pasted here, my lord. In 34.
So you have heard it. Put in your written notes. What else is? We'll want to look at the clause only. Relevant clauses.
It's just some time to arrange the papers, you know. That's only, my lord. I know the background, will just give me.
Come back next Tuesday. আচ্ছা একটা অনেক একটা আপনি না করে দেবেন every Tuesday assign.
Highly obliged, Lordship.
On the prayer of learned counsel for the parties, let the matter stand adjourned till July 1, 2025. Full stop. It is made clear that since this is an assigned matter, no further adjournment would be granted.
Obliged.
The parties are requested to come prepared with their brief written notes of arguments on the returnable date, as well as advance oral arguments.
Lordship.
Thank you.
My lord, I beg to appear in both the 6 and 7 as the
For the respondent?
respondent.
Well, Lord, this is my appeal, and
Yes.
my lord, and in an appeal, my lord, an application has been made for impediment of my client. During the pendency of the appeal, my lord, the interest in the property is a suit for eviction. Well, my client, I should not say my client, the NICO, the company NICO Corporation Limited filed a suit for eviction.
Yes.
In respect of the property which is situated here.
Eviction on the ground of trespasser or what?
License. Even license
Terminated? Yes.
Terminated. The suit was heard ex parte in the sense, my lord, the defendant, though served, did not, my lord, contest the suit.
Right.
A decree for eviction, I thought, as a matter of course would be passed, but on the basis of peculiar judgment, I should not say peculiar, but my lord, I should. It's a rather unusual judgment. Let me put it this way.
Yes.
The court had dismissed my suit.
Please take your seat. Yes.
My lord, I have something to say before my, excuse me, Mr. Mitchell.
Yes.
My learned friend has made an application for addition of party because he is a purchaser landlord.
Ah.
He purchased the property in an auction sale held by the official liquidator because the
Right.
company went on liquidation.
Right.
Now that sale itself, my client has challenged, and it is now pending Supreme Court order before the Honorable Supreme Court for final decision whether the sale is legally valid or not. And that
Lost
is
in a forum.
fixed.
You lost in the first forum.
No, 4 forums. If
My lord, this is the Supreme Court order. I like to yes,
came back
yes,
again, my lord.
yes, my lord. I like to put all these things on record. Therefore, I'm praying before your lordship
There was no direction for affidavits regarding
No,
the can.
I am asking for a direction for affidavit.
Mr.
The
Mitra, you have
addition
to
of
wait for
parcel.
some.
My respectful submission is this, that this is a simple application for impleadment by reason of the fact that this particular property was put up for, well, what happened was this company, Nico, who is the decree holder, well, he went into corporate insolvency resolution process and, my lord, and in liquidation. And, my lord, before NCLT, my lord, the property was sold after, my lord, public auction by the liquidator. And, my lord, after that, on, my lord, my client, in respect of a portion of the property, became the highest bidder. And, my lord, property was sold, conveyance was executed, possession was, my lord, possession certificate was issued, entire money has been paid.
Mr. Mitra, we are being very candid. If you dispose of the order, this addition of party application without giving an opportunity to file opposition,
My
that
lord.
will be the first ground of challenge, obviously.
Yes,
So let us give them. This is pending since long. You have got a copy since long. We'll give you 1 week's time to file your opposition.
My lord, that will be too short for me. I want at least 3 weeks time to file the affidavit because it's a thick one. I like to put a lot of documents on record. Unless I put them on affidavit, I cannot argue over that.
These are pending for so long. So
Yes, my lord,
2014,
I
series of 2014, and this was served on you.
3 weeks I am asking
3
for.
weeks we can't give you.
Then a fortnight at least.
Fortnight will.
Fortnight.
Fortnight, 1 week,
My
and we'll take.
grandfather's client is a lawyer. I am sure, my lord, he has got his affidavit ready.
No, my lord. No. It's a lawyer's own case.
Should we release the matter?
No. No. This is just purely, my lord, a commercial matter. This is
Anyway,
nothing to do.
yes. We are shutting our eyes. On the prayer of London Senior Counsel appearing for the respondent in the appeal, comma, the respondent is granted leave to file affidavit in opposition, is directed to file affidavit in opposition to Can 2 of 2025 within a fortnight from date. A reply, if any, shall be filed within a week thereafter. The appeal along with the application shall be listed for hearing next on July 22, 2025. 22nd July, please come back, Mr. Mitra and Ms.
Well,
Mitra.
can
July
it is
2022 July.
That's a Tuesday.
That's a Tuesday. Well, can it be, my lord, that the appeal and the application both appear on
That is our direction.
your lordship?
Appeal and the application shall be.
Application, my lord, this is a very short appeal.
We'll decide the application and then take up the
Very,
appeal.
very short. Very short.
Short appeal,
Very short. I
appeal.
will not argue more than 3
Well,
minutes.
this is the only point on which he agrees.
Yes. I know your lordship knows the law, so it will take me 3 to 4
There you may be mistaken, but 3 minutes remains, even if I don't know
3
that.
weeks. 3 weeks. So
Right.
matter is to appear in the month of July.
22nd of July to be precise.
Grateful to you.
Application along with the appeal, we'll decide the application, immediately take up the appeal. Your 3 minutes there, whatever.
I'm grateful to you.
I am very grateful to your lordship. Grateful to you. Your lordships were sitting in a better court, my lord, earlier. Courtroom number 16.
We have been evicted without due process of law by the master of the roster, without any opportunity of hearing.
If there is
And our officers are complaining because of these files. The first
Quite
appeal
right,
files
my
are very bulky.
my lord, if there is any way I can defend your lordship, my lord, without payment of any fees, I shall definitely, my lord.
Thank you, sir.
Yes,
No, but the difficulty is probably that's in anticipation of the incomings.
Right.
They are both much senior too, so they deserve better.
So, one of them. Or
Both. In between Justice Somen and Justice Tapabrata Chakraborty.
I see.
7 is connected probably. 6 and 7.
Yes.
6 and 7 দুটোতে common order. Next. None appears for either of the parties at the time of call, full stop. Let the matter stand adjourned till July 1, 2025. Next Tuesday. Yes. We'll come back in 5-6 minutes.
Melody in item number.
Item 9.
Melody in item number 9, my lord, I have instructions to.
Yes.
To my lord, appear on behalf of the appellant. My lord, may I, my lord, subject to, of course, my lord's kind convenience, my lord, may I come back any day next week?
Why, Mr. Banerjee? We are not granting adjournments generally because these are assigned matters pending for so long.
My lord, I am a little handicapped. My lord, the paper book is not with me. My lord, the application is with me, the soft copy. The paper book is not with me. My lord, the page numbers may not tell it there. That's the only difficulty, my lord, I have
Without
today.
the paper book, we cannot. Then we'll adjourn it till the next Tuesday. You are for the respondent.
I'm so sorry, my lord, to trouble your lordship.
On
Lord,
the
I'm
prayer
really
of the
sorry.
on the prayer of the appellant, the matter is adjourned till July 1, 2025. 1st July.
I'm so grateful, my lord.
Thank
Grateful, my lord. Grateful.
I appear on behalf of the appellant, my lord. I am led by my Mr. Rudraman Bhattacharya, my lord, just to point it out, my lord. He is suffering from COVID, my lord. He has not come in court, my lord. In that
Yes, Mr. Ghosh, what do you say?
I very well. I kindly keep it after.
So not regarding the COVID, whether we should grant adjournment.
After fortnight.
After fortnight, keeps it off. Whether.
Why fortnight? Well, since when was he afflicted?
Last week, last week.
I know.
That I know.
Since last
No,
week.
obviously. No. Since when? Because when we'll fix the next date.
He will join next week, my lord. Your lordship can keep next Tuesday.
Next Tuesday would be all right.
Yes, my lord.
Is first.
1st July?
1st July?
8th. Very good. An adjournment is sought on behalf of the appellant. Let the matter stand adjourned till July 8, 2025.
Grateful.
Please give the yes.
Yes.
11টা তোমার চলবে?
I'm appearing for the appellant, your lord.
Yes, Mr. Shastri. What is the matter?
This is an appeal, appeal under section 37. Before I
You are for the respondent.
may I have a leave? May I have a leave to file the certified copy because it was filed without certified copy. The matter was heard. It was released. Hence, it's
No, it was released at the order 41 stage.
no at this stage because the learned division bench, while passing the interim order, felt that he knows the respondent. Hence, he released on the personal grounds.
We also probably know her. Therefore, we are.
Lordship, I will indicate what's happening. I know my learned friend will seek a time. I am opposing the time. Let's kindly hear me.
My lord,
All right.
my lord will kindly hear me for 30 seconds. My lord, I am not directly praying for a time. My lord, this is a change brief. I received the brief half an hour back. My lord, I am arguing with my senior's brief. He is also unavailable. If my lord grants the condition that no further adjournments will be granted, I would be grateful. If not, then my friend can continue.
Yes, kindly hear it out. This is an appeal under section 37 against an ex parte order, which was obtained in a section 9 proceeding on 1st October 2024. At that point, when the appeal was, the order was passed, the petition copy was not served. We preferred an appeal. We got a leave to move it. The 2 points we had raised in the appeal is that the order which has been passed by the section 9 court is a final arbitral award which has been passed, which could not have been passed. And second, it is a pure commercial dispute. The learned court did not have the territorial jurisdiction to entertain the matter. This is important.
Editorial or subject matter?
Subject matter dispute was commercial. It could not entertain the matter. Thereafter, we carried out this appeal. There was a discussion of a settlement. In the meantime, pursuant to the appeal, lot of events have flowed. We have prepared a list of dates also. The respondents has taken step for unilateral appointment of the arbitrator, which was challenged by us. Thereafter, my learned friend's client have filed a.
Don't have another copy?
I'm just having one copy.
You have to give a copy to them also.
Yeah, I'm giving a copy to them. I have just pleaded the events which has happened subsequent to this. Thereafter, a section 14 was filed challenging the unilateral appointment. They filed a section 11 in the commercial side of the court. That was dismissed because they did not, they appointed unilateral appointment to arbitrator. A second section 11 was filed on the commercial side. I went back to the trial court and said, look, my learned friend is doing a forum shopping. At one hand, he's saying it's not a commercial dispute. Submissions have been filed in the trial court. And the other hand is approaching the commercial side of the court.
Who is leading you?
My lord, I'm being led by Mr. Supratim Dhar.
Supratim?
Dhar.
My lord.
What about the commercial code perspective?
My lord, I actually,
You're
my
not-
lord, I cannot.
Mr. Sastry, let us take it up next week. He's handicapped. Why put
Yes,
him
my-
in?
yes, my lord.
Only thing, the decision on the commercial aspect is reserved for the trial court. I'll indicate. My learned friend is appearing in the section 11 stage, pursuing everything. I am saying there is no arbitration agreement, but the fact of the matter,
Keeping all questions open, we can then relegate it to the trial court.
kindly keep it direct the trial, because the judgment is reserved. It is to be yet to be pronounced on the decision of the maintainability of the petition.
Maintainability of the section 9.
Section 9 on the ground that the court, this is a pure commercial dispute.
It was a district court.
It's a district
Yes,
court,
ma'am.
Barasat.
So then let us dispose of the appeal with that.
With that direction, because
direction.
they have been moving here and for. That's the only concern I have.
So wasting for the time, keeping
Exactly.
it pending here.
I
and all.
would say, but without considering, because the order itself, you
So
can-
we'll make it clear that we have not entered into the merits. Otherwise,
Yes,
either of you will be prejudiced.
yes.
When is the next date?
It's reserved on 1st of June, 9th of June.
Judgment is already
Judgment reserved on the point of the maintainability.
reserved on 9th of June.
9th of June.
Very well. Have you filed your objection to the section 9 there?
I have filed only an application challenging the
Only that
jurisdiction.
maintainability.
I have not entered into the merits, because my points in a section 11 code which I have taken, I don't have an arbitration agreement with them. I succeeded in the first time, and they had filed a section 11. So it is being contested.
Learned counsel appearing for the appellant. No, it is clear though. The present appeal has been preferred under section 37 of the Arbitration and Conciliation Act 1996 against an order passed in an application under section 9 of the said act. Full stop, next para. Apart from contending that by virtue of the impugned order, virtually the main relief of the arbitrable dispute itself has been granted, learned counsel argues that the dispute comes within the ambit of a commercial dispute, quote unquote, within the definition of the Commercial Courts Act 2015, which has been virtually admitted by the respondents in their application under section 11 of the 1996 Act, and as such, the learned judge passing the impugned order, not being a commercial court, did not have subject matter jurisdiction to decide on the prayer of the respondents. For sub next para. However, at this juncture, it is also pointed out that the issue of maintainability of the application under section 9 before a non-commercial court has been raised by way of a separate application in the proceeding under section 9 of the 1996 Act by the present appellant, which has already been heard by the learned section 9 court, and judgment has been reserved. Since we are apprised that the hearing was concluded on June 9, 2025, and we are already on June 24, 2025, without going into the merits of the case, which might influence the decision of the section 9 court and the other proceedings, we intend to dispose of the present appeal with a request to the learned court taking up the section 9 application to pass orders on the maintainability application on the appellant within a limited period, keeping it open for the parties to raise all their contentions before the said court and before all other forums. Full stop, next para. Accordingly, FMAT number 394 of 2024 is disposed of without entering into the merits of the matter, by requesting the learned judge taking up the section 9 application to dispose of the maintainability application filed therein by the appellant as expeditiously as possible, positively within a fortnight from the date of communication of this order to the said court. Full stop, next para. We make it abundantly clear that that we have not gone into the contentions of either of the parties on merits, and the above observations or the disposal of the present appeal shall not unduly influence the learned court taking up the Section 9 application and stroke or any other court or forum. No arrest to costs. Thank you. Dispose of judgment for me. Thank you. Great. Section 11% reject হয়েছে। একতরফা তো করতে পারে না এটা। ওটা দিয়ে দাও, can dispose of it. Yes, Mr. Gaur.
Lord, this is a respondent's application in a pending Lord appeal for enhancement of the occupation charges at the market rent level. Now, Lord, this appeal, Lord, was admitted long time back, Lord, sometimes in 1977. And Lord, on admission, the then contractual rent of 1,473 was directed to be paid as occupation charges. Lord,
in those days, occupation charges were directed?
Yes, Lord, it was damages, not occupation charges, as damages.
I didn't have any idea.
Justice, Lord, I find, Lord, the order is at page 15A.
Appeal is still pending, Mr. Court.
Lord, the problem is that, Lord, the matter was dismissed for default. And then your Lordship restored the matter. That order is at page 27.
It was dismissed in 2022. 2023, Lordship restored it, Willard, with a liberty that they will be entitled to make an application for enhancement of the compensation charges. That's
Lord,
recorded in the order.
Page 27 is the order at 28, paragraph 8.
Yes. Occupation charges and quantum. Yes.
Lord,
Lordship has permitted.
This is an application, Lord, pursuant to this leave.
Right.
And in fact, Lord, what we say today is that there is an area, this is 135A Canning Street. This is, Lord, in the heart of the city, Bada Bazaar. And Lord, this area is about 5,600 square feet that is being occupied by the appellant.
A one-time payment of 10,000 at that time was directed.
Directed because, Lord, there were areas, no, about 1,20,000 was the areas which was directed to be, Lord, disbursed, if your Lord, in installments. Kindly, Lord,
it
come
continues. Acha, right.
Page 18A, your Lordships will find, Lord, a better copy. The second paragraph.
Yes.
It is not in dispute that out of such and such, the appellant have paid 1,13,000 towards the areas so that they are in default in respect of 2 installment, one for 4,000, the other is 3,000. Also not in dispute, etc. This was directed that then, Lord, it says the areas in regard to 4,420, thus the total amount still due is 7,000 plus such and such in view of
What is this 7,000?
7,000 is, Lord, the further due which had fallen in the meantime. So this calculation was there, and Lord, then the last paragraph, it says that this 11,420 will be paid.
But that was
in 77.
77.
Yes.
And Lord, the current occupation charges, and kindly see the 190 name, Lord, the paragraph, we further make it clear.
Yes.
Now that the areas have been paid off as assessed by us by our earlier order, the petitioner must go on paying, depositing month by month the monthly damages at the rate of 1,473.40 within 15th of the month succeeding the first of such deposits. So and so.
That was at the rate of the rent which was being paid
That
by.
was the contractual rent under the lease. The lease was terminated, and Lord, that was the lease. Now, Lord, the basis. Yeah.
The stage. What is the stage of the appeal? Otherwise,
Paper books, I have got the soft copy of the paper books. Hard copy is tracing, but I have the soft copy. He has an application, my lord, asking for 10 lakhs. I have the documents, my lord, I can show, my lord, it's lesser. I don't say it's 1400.
Was there a direction for affidavits in this?
No, no. This is
The
appealing
first
for
thing.
the first time.
So then Mr. Court will direct affidavit because they have to, they can.
I'll show the documents. I have 3 rent receipts. I'll show. My lord, lordship
in
takes a
fact-
strikes the balance. Lordship has
In,
done
in
into
fact,
my
that
matters.
page 29
Yes.
is the new document that we have annexed, that at the present moment in the same property, this is the lease that we have granted, which is below 2,33,485 for a lesser area.
Acha.
The area is about 1,480 square feet. This is the evidence that we have produced in page 29.
Where do we get the square feet?
We will kindly see the re part. Office
top
space
portion, top portion.
on terrace measuring about 1480 square feet. Your premises so and so, and this is the rate. So,
Mr. Ghosh will direct grant you for a fortnight's time.
Fortnight's time, I have lordship strikes the balance. Lordship does it, my lord, so many times for
Well,
that.
The present application is for enhancement of the occupation charges payable as condition for stay granted in favor of the appellant. First of next parallel, senior counsel appearing for the respondent seeks to rely upon the documents seeks to rely primarily on the documents annexed as annexure G to the present application to contend that premises, it's in the same building or
same building,
that another office space on the self-same building as the suit property, comma, which is measuring about 1480 square feet, bracket A, less than the suit premises, bracket closed, was let out for a monthly rent of rupees 2,56,833. Full stop. Accordingly, comma, it is submitted that commensurate occupation charges be imposed upon the appellant as well for as a condition for continuance of the stay. Full stop. Next parallel, senior counsel appearing for the respondent controverts such allegations and seeks to bring on record relevant documents in such context. Full stop. Accordingly, the appellant stroke opposite party is directed to file its affidavit in opposition to the Can 3 of 2025 within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing next on July 22, 2025, 22nd July.
could it have some precedence, my lord?
আচ্ছা July 22 না করে একটু আগে করে দিন not July 22 July 16 because 15th that
Yes,
period ends.
yes.
So July 16, 2022.
Much. Much.
Mr. Kaur, please ask your learned junior to ensure that whoever, I mean, is the advocate on record, that the copy is given well in advance so that Mr. Ghosh can come. The reply.
My lord. My lord.
I'm on behalf of the petitioner and my client will not further.
ডিপার্টমেন্টই পাচ্ছে না আমাদের কোর্টে এসে পড়ে নেই তো yes
I'm on behalf of the petitioner. My client will not further proceed with this.
don't want to proceed further. Very well. Learned counsel appearing for the appellant submits that the appellant does not want to proceed any further with the appeal. Accordingly, FMA 337 of 2010 along with Can 5 of 2023 are dismissed for non-prosecution without any order as to costs. Thank you. নামটা নিয়ে নেবেন আইডেন্টি স্টে নিয়ে বসে আছে মানে ও পয়সাও জমা দিতে বলেছে ডিফেক্টটা কি হয়েছে কিনা দেখে নি করে দিচ্ছি, ডিফেক্ট কিওর করে দিচ্ছি। None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Lord, I appear on behalf of the appellant. I am appearing with Mr. Mukesh Gupta.
Mr.
Mukesh Gupta. He's the advocate on record.
Yes.
Lord, there are two defects, Lord. One is, Lord, a formal defect. That is, Lord, the application being can number 2 for deleting the name of the respondent number 5 because she is the mother and all her
Heirs are record.
daughters are on record. My Lord can.
Which one is that? Which can?
2. Can 2. My Lord has already recorded that in the last order that in fact we have filed means it is cured.
Formally just.
Formally it is cured. But
So who is that? Who was what was a respondent of 5? Period.
respondent number 5.
So we'll first. Anybody appearing for the other side, Mr. Mukherjee?
You appear for each other. Well, previously appeared, my lord, Mr. Parthopratim Roy and Mr. Dutiman Banerjee. They appeared.
So let us allow this can 2 first. That is an innocuous. In view of the innocuous nature of the prayer meet, can 2 of 2023 is taken up for hearing, despite none appearing for the respondents at the time of call. Full stop. It has been pleaded in the said application that the respondent number 5 has met her demise and her heirs and legal representatives are already on record. Full stop. Accordingly, can 2 of 2023 is allowed, thereby directing the name of the respondent number, the deceased respondent of 5 to be expunged from the records. Full stop. Necessary consequential amendment to the cause title of the memorandum of appeal shall be carried out by the learned advocate on record for the appellant during the course of the day. Mr. Mukherjee, please ensure that the deletion is done in the memo during the course of the day. Full stop. No orders to cost. Yes. What is can 1?
Can 1, my lord, is an application under section 45 of the Indian Evidence Act. It has been observed, my lord, by order dated August 8, 2022 that this can, that is the expert evidence application for
Will be heard along with the appeal.
along with the appeal.
Naturally, because the nature of
Yes.
So that has already been, direction has been given.
Yes, on 8th August 2000, but the second defect is there. That is, my lord, the learned lower court has to correct, the trial court has to correct the record. So, kindly see my lord's own last order, my lord. Last 2 orders. One is, my lord, in the month of 23rd of February 2023. Another is, my lord, 16th March 2023. My lord, in the first order, the learned registered administration was directed, my lord, to send down the lower court record for correction. That is on 23rd February 2023. Kindly see order dated 23rd February 2023, last paragraph.
Twenty-third February or 2. ওটা বাদ দিয়ে সব আছে। পেয়েছেন
And thereafter, my lord, on 16th March, again same.
That has not yet.
I am not.
Court records have not come.
I
Seek a report from the office.
Yes. Kindly, my lord, call for a report from the office of the learned registered administration and let it appear after 1 week or so. 2 consecutive orders were passed by your lordship, my lord. Correction টা করে that the section 47 application of the Indian Evidence Act, can one will be heard
With that.
with that. Section 5 in respect of this deleting the name.
Paper books have been prepared, no?
Not yet.
Or lower court records
Lower
notice.
court records are not yet come.
There was a direction on the appellant to prepare requisition.
Yes, yes, yes.
That is
yes.
after the lower court records.
Yes, yes. Your order dated 8th August 2022, lot page 4. Immediately after
Record
arrival
এসে
of
কিন্তু ওদের উপর নোটিশ যায়নি, নোটিশ সার্ভ না হলে কি করে হবে? এটা কি
to 8. So they did not file their vocalatnama for respondent number 5. That is the mother who has died. Her name has already been deleted.
then it's ready as
Then-
that service.
Then there is no need to serve any notice.
No. Sealed cover content.
7 except respondent number 5, they appeared for all other respondents.
Records are found to be complete. This. একটা যা বললাম তারপরে in view of the deletion of the name of respondent number 5 and the other respondents appearing through their learned advocate comma further service of notice of the appeal on the respondents is dispensed with full stop. From the office report dated June 18 2025 it transpires that 4 files of the trial court records in connection with the partition suit have been received by this court full stop. From the order dated from the previous office report dated March 9 2023 comma it is seen that one sealed cover containing the trial court records was also received full stop. The office shall examine the records trial court records and comma upon being found to be complete comma take necessary steps for service of notice of arrival on the trial court records on the learned advocate for the appellant. Full stop. It is expected that such exercise shall be completed within a fortnight from date. Full stop. Upon the receipt of such notice of arrival of the trial court records, comma, the appellant shall prepare and file the requisite number of paper books as per previous direction. Whatever was the previous direction, to do.
And my lord, Mr. Gupta will delete the name pursuant to the leave of your lord.
Yes, right now you can do that. From the memorandum of appeal, that will do.
I'm great. I'm great.
With the leave of the court as per the
Yes, yes.
He knows.
My lord. ওই কোণাটা।
I am for the appellant.
Yes.
This is a matrimonial appeal, Lordship. Our application is scan 2 for stay of operation of the judgment order of expertise order judgment order of divorce.
Divorce degree?
Lordship,
Divorce degree?
divorce decree.
You are challenging a divorce degree?
Lordship,
You are asking for stay of that?
Lordship. What happened during the respondent husband filed first application for divorce before the Court of Learned Additional Discharge at Barakpur during pendency of that matrimonial suit. Subsequently, another application for suit for divorce was filed in the Court of Learned Discharge at Barasat.
You have remarried, Mr. Rai?
Lordship, married, Lordship, kindly admit the appeal and
Appeal will give you directions to file paper books and all.
Lordship, but one thing, Lordship, kindly consider, respondent is an army man. His wife and 2 children, they were getting medical facilities from the Command Hospital, Calcutta. During, as the divorce took, when order passed, now they are not allowing them to get the medical facilities. If your Lordship kindly consider that aspect to
Then you file a proper application for alimony covering the entire amount. Because you were already getting something. Why didn't you already file an application for alimony? We don't understand. You should have filed an alimony asking for an equal amount at least. File an application for alimony.
Already they are getting around 23,000. Alimony under 125 is getting the same.
Under 125?
not regularly paying, Lordship.
For that you have to take steps.
Lordship, Lordship, I am on that, if your lordship kindly limited purpose stay the operation of the order. In that
How
event,
can we stay the operation of a divorce decree? That has already been culminated. It has already culminated in his second marriage. Staying that would not mean anything. There is no scope. It has become infructuous.
So the younger son is staying with me, but I am paying the alimony in the account of my wife. Rupees 5,000.
your lordship kindly allow me to file application for alimony.
Why we need not allow you. We file it. Can 2 of 2023 is an application for stay of operation of the impugned divorce decree obtained by the respondent husband. For sub next para, it is submitted. It is apprised to the court that the respondent husband has already contracted a second marriage. For sub as such, comma, can 2 of 2023 is disposed of as infructuous without any orders to cost. Full stop. It is relevant to mention here that since marriage under under such circumstances is neither void nor voidable, and as such we cannot make any observation regarding the second marriage at this juncture. For sub needless to say, comma, the second marriage would be subject to the outcome of the appeal. For sub next para, learned counsel for the appellant wife submits that previously, comma, in the capacity of the wife and child of the wife of the respondent, comma, the petitioner and her sons used to get certain remunerations which have been stopped due to the divorce decree. For sub next para, learned counsel for the respondent submits that pursuant to an order of court under section 125 of the Code of Criminal Procedure, comma, an amount of rupees 23,000 per month,
20,000.
20,000 per month
6,000, 5,000.
is being paid to the appellant wife. Full stop. However, comma, learned counsel for the appellant submits that regular payments are not being made, which is disputed by the respondent. Full stop. Be that as it may, comma, it will be open to the appellant wife to take appropriate proceedings for execution in the event the payments are not being made in pursuance of the order under section 125 of the Code of Criminal Procedure. Full stop. Next para. In the event the appellant wife is of the perception that further alimony is required, comma, it will be open to the appellant wife to file an appropriate application for alimony. Full stop. Next para. What was can 1? Section 5?
Section 5.
That must have been very well. In view of the appearance of the respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. There was no direction for the trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is filed. Same is made ready for hearing. If in the meantime you file any alimony application, mention it. Will.
I'm good.
Thank you.
Item number 17, although I'm criminally out of time.
Last chance was given to you.
And I'm filing
Yes,
my-
but you have to take the microphone way up.
My lord, please give short passover, please.
On the last occasion, they pray for adjournment. Now you pray for adjournment. No 50-50 case here.
Lordship, should your lordships allow, I'll just file my affidavit in opposition.
Opposition? Opposition file it, yes.
My opposition to Can 1, which was their injunction application. I'm already suffering an injunction.
At the time of call, comma, an adjournment is sought on behalf of the appellant. So we find from the records that on June 23, 2025, comma, since an adjournment had been sought on behalf of the appearing respondents, comma, the matter was fixed as a last chance for the respondents to file their affidavit in opposition and to appear. Full stop. Pursuant to such observation, comma, the respondent is the appearing respondents are represented through their learned counsel, who files the affidavit in opposition on behalf of the defendant. What is this defendant business?
No, your lordship, I guess that's a
Only one defendant respondent.
No, that is respondent numbers 1, 5 to 10 and 12. That's a typographical mistake which I.
1, 5 to 10 and 12, yes. কি বললাম কোথায় ছাড়লাম তন্ময়? And files?
And files available to office.
To can 1 of 2024 on behalf of the appearing respondent numbers 1, 5 to 10 and 12. Full stop. Full stop na, within bracket. Although the same has been erroneously captioned as affidavit in opposition on behalf of the double inverted with the defendant. Double inverted close, bracket close. Full stop. Let such affidavit in opposition be kept on record. The time for filing reply is extended for a week from date. Full stop. The matter be listed under the same heading on July 1, 2025.
Very grateful.
Thank you.
I apologize for the mistake.
No. Yes.
Lordship, I am appearing on behalf of the appellant. I have a short prayer that for weeks accommodation may be given. The matter was lastly taken up in the year 2023 and it's appearing for the first time after such a long gap. Praying if a week's accommodation may be given.
An adjournment is sought on behalf of the appellant. No, which one? You are appearing for Prosenjit Nath, who is appearing?
19, I am for Prosenjit Nath. That is a
For
cross
who?
appeal.
For
19 is
the
a cross
appellant, for the appellant, then they're the appellant in any case. An adjournment is sought on behalf of the appellant for a week. Full stop. Accordingly, let the matter stand adjourned till July 1, 2025.
appeal. I'd like to appear for the appellant in this matter.
Yes.
Lord, yesterday, my Lord, she was pleased to, my Lord, show some grace to me. Lord, I'll just place what has happened.
What about this app? This is an application for expeditious hearing.
That your Lordship kindly disregards. There is, my Lord, filed, my Lord, under some advice, my Lord, to get the matter heard. But I'll be
No,
very
no,
candid with your
directions for
Lordship.
paper books and all were not given.
That were not given. This is the first time it is coming up. The appeal is coming for the first time.
So we'll pass those directions. There is some issue as to maintainability of the appeal.
No, my Lord, I say, my Lord, I am for the appellant, my Lord, I will certainly not show. But, my Lord, there is one thing I had tried to, my Lord, submit on the merits of the matter. But if your Lordship kindly grants direction for affidavit, my Lord, for my Lord, exchange of paper books, my Lord, then, my Lord, I'll be able to produce those documents which I'll be relying on. Otherwise, I'll have to place the facts verbally only. My Lord, what has happened here is, my Lord, the wife, after taking a huge sum of money, has, my Lord, stopped appearing in the mutual divorce court. That is what has happened, and upon that, my Lord, the learned trial court was pleased to hold that the matter be dismissed for default, considering me, a joint petitioner, to be a respondent. That is the whole issue involved.
No, but what is the position of law? If 13B cannot be allowed without
that
both
is,
sides,
my Lord, I tried to, my
if
Lord,
it has taken advantage, you have other remedies.
perhaps, my Lord, that can be gone into by your Lordships. Perhaps, my Lord, I can have some arguments to place because I have found, my Lord, one Rajasthan High Court judgment at the very least, my Lord, where it says, my Lord.
Yes, no, if she has done that, I mean, she should be, she should pay up. But whether we in this proceeding, we can very well will hear the appeal on merits when you hear it.
Yes, your Lordship.
Can 1 of 2025 is an application for expeditious hearing of the appeal. Push up in view of the innocuous nature of the prayer, comma, we do not direct prior service of notice on the respondent. Pushed up. Since a matrimonial matter is inherently urgent, comma, can 1 of 2025 is disposed of by directing the appellant to put in postal costs and requisites for service of notice of the appeal on the respondent, comma, within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
So deployed.
In this matter, my lord, last occasion Lordship directed me to serve, my lord. Thereafter we have served, my lord. It has returned, my lord, with, my lord, it is written in the, my lord, your Lordship kindly see in envelope. It is written at the back of the envelope. It is written I oblique A. Mane insufficient address.
Complete address.
Insufficient address.
Insufficient address.
Yes,
Yes.
ma'am. Insufficient or incomplete address.
Yes.
Because
Insufficient is right. That is the expression.
but your lordship will find that this respondent has filed the petition with the same address. In opposition, he affirmed with the same address.
This arises from what matter? Matrimonial suit?
Matrimonial suit. Ex parte order of divorce, my lord.
So the respondent husband was the appellate, the petitioner there, obviously.
Yes, my lord.
This is his lord.
My lord.
What is the application for?
Well, application for its condolation of delay and stay is there, my lord. I mean, the delay is of long days, my lord.
You have served copies of both the applications.
Yes, my lord. No, my lord. Your lordship directed me to
Only
see-
can two.
Can 2 years. Yes.
Very well. What is the period of delay?
Well, 960 days, my lord.
Explanation?
Explanation is, my lord, she has in 2024 she came to know, and thereafter she initiated proceeding under Order 9, Rule 13, and that was dismissed, and both the Section 5 is rejected as it is not explained properly, and Miss case is rejected on the ground that it is barred by limitation, my lord.
You had initially appeared in the proceeding, in the divorce suit.
No, my lord. That is ex parte.
No, ex parte may mean that you initially appeared, then did not.
No, my lord.
At no point you have said that no summons.
No notice was served, and the notice was served in the address where I was not residing, my lord. I was after driven out from my husband's house, my lord. I was not allowed in my father's house to reside, my lord. I was residing in a remote corner by
It will be
making.
very risky to pass a stay order. 900 days have elapsed. He must have married in the meantime. Must have remarried in the meantime. You have to find out his address, because after 900
But
days,
my
yes.
daughter, she's 16 years old. He's
Miss
residing
Khatri,
with.
we could have said that because he gave that address at the time of filing of the suit, he is avoiding service. But we cannot say that after 900 days, because he might have given that address, decree was passed 900 days back, 900 days from filing of this appeal.
But
Still earlier. He might have changed address.
No, Milo, he's residing. My daughter, 16 years old daughter, is residing in that house. I confirm that my husband is residing there.
You try to serve again.
Yes, my lord.
From the affidavit of service, it transpires that the postal article returned with the endorsement insufficient address. For next para, learned counsel for the petitioner submits that the respondent husband filed the divorce suit from which the present appeal arises from the self-same address, and as such is deliberately avoiding service. For next para, however, comma, since the
in opposition also, Milo, he has given objection with same address.
Since, however, comma, since the appeal has been preferred after more than 900 days from the
960 days.
From the passing of the impugned decree, comma, we are not confident that the address of the husband is still the same from which he filed the divorce suit. Next para, learned counsel for the appellant petitioner, however, submits that you have only one daughter, she is residing with the father.
Yes, 16 years old.
That submits that the 16-year-old daughter of the parties, comma, who is residing with her father, the respondent, comma, is residing at the address as given in the present cause title. As such, comma, it should be construed that the address of the husband, comma, with whom the daughter is living, comma, is also the same. Be that as it may, comma, the appellant stroke petitioner, comma, for the ends of justice, comma, shall serve a fresh copy of the application of both the applications, serve both the applications on the respondent husband, indicating that the applications shall be listed for hearing on July 15, 2025, when an affidavit of service to that effect shall be filed afresh by the appellant stroke petitioner. Let us see.
Before taking up the matter, my lord, item number 13, my lord, my name was not given in the.
We have passed an order now.
The order has passed. I am not saying, my lord, only my name.
No, we don't know what order we have passed. We might have recorded none appears.
Not prosecuted. appellant has taken back the.
নন প্রসিকিউশন 13 কে ছিল কি তোমরা কেউ ছিলে তুমি ছিলে
My learned, sir.
কে ছিল অনিন্দিতাকে সিটটা দিয়ে দাও তো। একটু বলে দিও যাতে 13 ঢুকিয়ে দেয় আইটেম নাম্বার ইউ হ্যাভ রিটেন দেয়ার
30, yes. Keep leverage.
Item number 6. Item number 22. Before my learned friend submits.
use the mic
My lord.
See, before my learned.
use the mic we can't hear you
In item number 22, Lordship. Before
shout
Before my learned friend submits, Lordship, may I just pray there was a direction for filing affidavit in opposition, Lordship. The client is a senior citizen lady, Lordship. She could not. We have contacted him. We have received instruction. I will be seeking a week's extension to file our affidavit. in
senior
opposition.
citizen means what is the age
65 years, sir.
65 is not so old that she cannot sign a document
She is no, she can, Lordship, but due to some miscommunication.
what is the matter about what do you say to this
My lord, actually, my lord, I am not the applicant. Actually, I am here to seek accommodation. I am also seeking accommodation.
so how long
1 week, Lordship.
on the prayer of the respondents the time for filing affidavit in opposition is extended for a week from date full stop reply if any shall be filed within 1 week thereafter the matter shall be listed next on July 15 2025
I am for the appellant, my lord. I am not pressing the appeal, my lord.
You are not
pressing the non-prosecution. Okay, let it be dismissed as non.
why
But I'll file my affidavit. We were supposed to file an affidavit. Very
From
fair,
the-
my lord, I'll tell you, Lordship. X filed the suit claiming to be a residuary legatee of the property.
X files
Plaintiff filed the suit claiming.
X files
X.
yes X files the suit
We've disclosed deeds where the X who had actually sold it in his lifetime. Plaintiff
Lord,
files a suit to be claiming to be a residuary legatee of X. We've disclosed deeds by which X has sold the property in his lifetime. But very
Lord,
fair.
Form and substance is, my lord, plaintiff's predecessor itself as this is a case of loss of title. My lord, and this is my lord matter.
the affidavit in opposition filed today be kept on record full stop in any event learned counsel appearing for the appellant submits that the appellant does not want to proceed any further with the appeal full stop accordingly FMA 539 of 2025 along with Can 1 of 2025 are dismissed for non-prosecution without any orders to cost. The written instructions in that regard filed by learned counsel for the appellant today be kept on record. Thank you.
There was an interim order. Would you
Vacated.
Interim orders, if any, stand vacated.
This pertains to a my lord family matter of a very senior advocate of this court. Now, my
Who?
lord,
One of the parties.
No, no.
Can't
yes,
hear you. Yes.
Yes. Not one of the parties, my lord. Family matter, my lord. My client is related, my lord. When he saw those documents, he said, "Don't proceed."
What's his surname?
Mukherjee.
Yes. Yes.
24, my lord, I appear.
Yes, Mr. Chandra.
No, এটা না 26 ওটা মনে হয়, হ্যাঁ? ওটা মনে হয় 26 একবার চেক করে নিন স্যার। Yeah, I'm sorry.
You are granted an injunction. You have served on the other side.
My lord, I'm sorry, my lord.
Wrong matter. Wrong number.
This is 24. I'm appearing for the.
Yes.
Mr. Lopshi was.
Copy has been served.
Yes, my lord, I have served. 3, 4.
Good service affected, Mr. Mukherjee.
My lord, these 2, 3, 4 has refused.
Refused is good service, and one received. So we'll dispose of the application Can 1 with the injunction.
Orderটা কোথায়? Extra copy আছে extra copy.
Your suit is for specific performance.
And my
Only
lord,
on the ground that defendant should be heard, it was refused.
Yes. And ultimately, my lord, your lordship was of the view that as because the agreement was not registered one, That was
You
decided.
changed that view.
My lord.
You
My-
remember that.
my-
You cited a judgment and
My-
changed that view.
my lord, that
Proviso to
basis
section
of that
49.
your lordship was pleased to proceed.
But they would be more intelligent if they appeared and got the appeal disposed of. Ad interim was refused by the trial court. By virtue of this, it will indefinitely go on.
Whereas, my lord, the respondent number 1,
Yes.
who is the new incumbent, he was not the agreement. He was the purchaser. My lord,
Then they
and
should
he-
just
yes,
appear and
my-
have this
Yes.
affidavit of service filed to be kept on record. Full stop. Service has properly been effected on the respondent number 1. Full stop. The other respondents have refused service, comma, which tantamounts to good service in law. Full stop. Accordingly, the application is taken up for hearing ex parte against the respondents. Full stop. Next para, we find from our order dated June 9, 2025 that we had recorded in detail the reasons for granting ad interim order. Full stop. Next para, the learned trial judge has refused ad interim order merely on the ground that the defendant number 1 should be given an opportunity of being heard, although an agreement for sale was produced before the trial court. Full stop. On the last occasion, comma, learned counsel for the appellant has had prima facie satisfied us by placing reliance on the judgment of such and such reported at আগের অর্ডারটাতে পেয়ে যাবে reported at 2025 SCC online SC 1067 and such reported at 2010 5 SCC 401 that in terms of the proviso to section 49 of the Registration Act 1908, comma, even an unregistered document can be received as evidence of a contract in a suit for specific performance. Full stop. Upon thus being convinced that a prima facie case for grant of injunction had been established, comma, and being satisfied that the balance of convenience and inconvenience is in favor of grant of injunction, comma, we had granted such ad interim order of injunction. Full stop. We further record that unless the injunction order as sought is granted, comma, the appellant may suffer irreparable injury and the LIS might become infructuous. Full stop. Also, comma, there is urgency involved in terms of the averments made in the injunction application filed before this court, which stand uncontroverted since the respondents choose not to appear or pray for any opportunity to file written affidavit in opposition. Full stop. Accordingly, can 1 of 2025 is allowed, comma, thereby restraining the respondents and or their men and agents by an order of injunction from selling, transferring, alienating and or creating any third party interest in respect of the suit property and or from changing the nature and character of the suit property in any manner till disposal of the injunction application. The appellant shall put in due requisites and postal costs for service of notice of the appeal on the respondents within a week from date. Full stop. You have all the papers. Will not call for the trial court records.
All papers.
In view of the relevant papers being available with the appellant, comma, we dispense with calling for the trial court records. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date, 6 weeks from date. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for here. Please put in the postal cost and all within a week.
My junior is,
Pardon?
My junior is asking, if your lordship so thinks that this injunction is, the interim injunction has already been granted in the by my lord, then the suit has to be heard by the trial court. So, if your lordship.
We could have done that if the appellant was, respondent was there. But today is fixed for hearing of the application. We cannot dispose of the appeal. We could have done that if that's why we said that they were intelligent. They would have come up and had the appeal disposed of. Then the suit could proceed. We have not granted any injunction stay in respect of the suit. Let the suit proceed.
Then one line.
You are already enjoying ad interim order. We will add that line. It is made clear that the pendency of the appeal before this court shall not preclude the learned trial judge from proceeding with the suit as well as the interlocutory applications pending before the said court. Have your injunction decided? And then mention that this has become infructuous.
Yes.
Next. Yes.
Lord, I appear for respondent numbers 1 and 2.
Respondent number 1 and 2. All right. They are the only contesting respondents.
My lord.
Lord, I am appearing for the pro forma respondent number 10 to 13, my lord.
10 to 13. You have been set up by him.
Yes, my lord.
You have been set up by him.
No.
My lordship, I am appearing on behalf of the appellate.
You are appearing for 1 to 9.
1 and 2.
The 3 to 9. What about them? No, 9 is Tika controller.
My lord, 3 to. Huh?
All are Bells.
No, 1 and 2, my lord, are the.
They have contested in the trial court.
They are
What is
the
the
main person
yes? What is the matter?
My lordship, on the earlier occasion, your lordship has passed a direction upon the respondent number 1, 2, and 3 to file an affidavit in opposition within 13th June. But my lordship, my client has received the copy on 19th June, and there
You
are
are for whom?
I am for the appellant.
Oh, you received a copy of that opposition.
Yes, my lordship.
Will condone that delay. Where is your reply?
My lordship, I have not prepared till now. Kindly, I am
Why
praying for-
19th June you have received? Today we are on 24th.
But my lordship, I have not received. My client has received, and thereafter.
No, but that is also not a fact.
Why one copy?
No, my lord, I'm sorry, my lord. I should have 2 copies.
He is not informed. File properly.
My lord, what happened, my lord? The learned I went to serve upon the learned
But?
advocate, but the learned advocate refused to accept it. I sent it by registered post. This is the service, my lord, which shows that they have received it on 17th. They have received it on 17th of June. Now, my lord, that is not the issue. The issue is, my lord, that there is a suit for partition. In that partition suit, they asked for an interim order of injunction. It was refused. Against that, they approached this honorable court. Now, my lord, I find, my lord, that much prior to filing of this suit, there was a probate proceedings. That probate
No,
proceeding.
but we can only do that if you at the time of hearing only.
That has been
But we can, if you have disclosed it in your opposition, we'll look into that. But file a proper opposition.
Kindly keep it at 2 p.m. my lord. I will prepare a second copy.
My lordship, I am seeking time, my lordship.
Because
We'll give you 1 week. We'll give them 1 week.
the difficulty
Grateful, your lordship.
is still 38th, my lord, not to make any construction, my lord. The construction work has started. There is a probate proceedings, my lord.
We are on
Disposed of-
24th.
Look,
We have granted injunction till 30th.
Yes,
my lordship.
No, my lord, the construction has been stalled, my lord. By virtue of that will executed by the grandfather, my lord, we are the beneficiaries. But that has been
No,
suppressed. in
during
the plan.
pendency of the application, we have.
No.
Yes.
It's been suppressed in the plan. That has been suppressed.
No, we granted injunction during pendency of the application.
On the first day, my lord, your lordship passed an order.
No, in our order dated 5th May. Fifth May, we admitted the appeal and granted injunction till disposal of the application. During pendency of the application.
Yes.
Not
Yes.
till 30th June.
Yes, your lordship.
Learned learned counsel for the appellant seeks some time to file affidavit reply. Full stop. Learned counsel for the respondent appearing respondent numbers 1 and 2 undertakes to file their opposition during the course of the day.
2 p.m. my lord, I will file.
In full stop next paragraph, the time for filing reply is extended till June 30, 2025. Full stop. The application shall be listed next on July 1, 2025 under the same head.
Grateful, your lordship.
File it so that একটা কপি করে এনে উনি ফাইল করে দেবেন দুটো ফাইল করে দেবেন ফাইল করলে এখানে ঢোকাবেন ভুল জায়গায়
Should have made 2
no
copies, my lord.
yes next
I have brought everything on record, man. Everything.
Pardon?
Brought everything on record. The petition, the order,
we
everything.
will consider that.
And it's the order passed by this honorable court. Great.
Yes.
One problem, my lord, one matter was going on, but the division bench rose for some meeting and fixed at 2 p.m. Justice Devabrata Chakraborty.
This could be completed.
This will completed, no problem.
Yes, Mr. Chaudhary, will you complete it?
Yes. Well, the defendant is an appellant before my lord. Lord, suit for partition. Lord, my application under Order 39, Rule 4, my lord, has been rejected. Lord, I have taken up, Lord, 2 points. My first point is suppression. My second point is that the learned trial judge has considered, Lord, a fact which is yet to see the light of the day in the plaint. an amendment application is filed that is not yet, my lord, been considered, allowed. That fact, my lord, has persuaded to the court, my lord, in rejecting my application. Now, my lord, the bare facts are,
Mr. Chaturvedi, in 3 minutes, this cannot be heard.
I did not see the watch.
11:12.
I'm so sorry.
In 3 minutes, probably this won't be heard.
I'm so
You will take at least 3 minutes to make the minimum submissions.
No, my lord, I did not see the watch, my lord. I'm
No,
so sorry.
2 p.m. you have.
Going on. Court rises for some urgent meeting.
So we'll keep it tomorrow itself, Mr. Chaturvedi, if you don't have any problem. Tomorrow itself.
Yes, yes, yes.
Since the matter cannot be concluded before recess and an adjournment is sought after recess by the respondents, comma, let the matter stand over for the day. Everything. Yeah, except the name of the learned senior advocate who asked for time. Yes. দেখো একটা কল করুন 27. If you are appearing, Mr. Mukherjee, this also won't be finished within 2.
It's very short matter.
What is that?
Lord, the partition suit.
You are asking for time.
Plaintiff respondent for 2 weeks time for filing
Why?
filing opposition.
We have already directed you long back. 11th June we have directed.
This is new brief for us and my.
Use the microphone, sir.
This is a new brief for us and this is a new.
Don't
brief.
take such new briefs. We won't extend time. Sorry.
Lord, the
My senior is actually
partition suit. Lord, the injunction was granted, Lord, in respect of nature, character, possession, transfer, alienation.
Are you enjoying an injunction?
No, I am not in. I am the defendant in this suit.
Oh.
Lord, what I propose is before your lordship that it is an agricultural land. Lord, the classification
The
of land
harvesting
shows.
can be done.
Yes,
But
that-
it will be a disputed question as to which part has been.
Lord, the entire suit property is Lord agricultural. It's
No, which part has been.
No, that's why Lord, the case made out in the plaint is that by mutual arrangement, everyone is possessing as per their own.
If both of you try to harvest the crops, then it will be very difficult. There will be a criminal case soon.
It will be, Lord, standstill so far as regards the harvesting process is concerned. If it is at least the nature character, Lord, possession, transfer, alienation, I am, Lord, is on, Lord, that. But since it is a agricultural land, if ultimately harvesting is not being allowed, then it will be the only, Lord, livelihood of the parties. And it is nowhere, Lord, disputed.
What is the status quo granted?
Lord, kindly see, Lord, the order.
From reaping the crops. Oh, status quo has been granted.
Yes, as a general.
Yes, why shouldn't we permit you to
Only to that end.
both of you to harvest the crops?
as per my direction from my senior counsel,
Who is your senior?
Mr. M.A. Samath.
No.
And Milord, why I say it is an admitted.
An adjournment is sought on behalf of the respondents, full stop. However, comma, we find that that copies of the application have already been served on the respondents and directions for affidavits were granted on June 11, 2025. Full stop, the affidavit of service filed to be kept on record. Full stop. We refuse to grant an adjournment of 2 weeks as prayed for by the respondents. Full stop. However, comma, for the ends of justice, comma, the time for filing affidavit in opposition is extended till June 30, 2020, we are on 24th, June 27, 2025, full stop. Reply, if any, shall be filed on the returnable date. The application shall next be listed on July 2, 2025. We are granting you 3-4 days for that. Within this Friday, you have to file the opposition. Yes, call.
My lord, item 25, Lordship granted me leave to file the opposition. May I just file?
Together,
My lord, I'm for the appellant, my lord.
Yes.
My lord, in last week, my lord, I had a viral fever, my lord. I could not able to prepare the affidavit in reflex. Kindly accommodate 2 days, my lord.
2 days.
2 days.
Yes.
Your lordship.
They have filed the affidavit in opposition, my lord. I got it.
You will file your reply.
I'll reply, my lord.
On the prayer of the appellant, comma, the time for filing reply is extended till
Up to 30th, my lord, ad interim injunctions is there. 30th June.
June 30, 2025. Full stop. The matter shall next be listed on July 2, 2025. 2nd July.
May I be allowed to file my affidavit?
Affidavit in opposition filed today be kept on record.
Respondent number 2, my lord.
Acha, affidavit in opposition filed on behalf of respondent 2 today be kept on record. Thank you.
Deeply obliged.
Yes. Hey, have them.
Item number 29, Your Lordship, I am for the appellant.
Yes.
As per Your Lordship's directions, Your Lordship, we have served the Lordship the copy of the application and the memo of appeal. On the last occasion, Your Lordship was pleased to pass an order on 22nd of May 2025, wherein Your Lordship has stayed Your Lordship the notices, but directed me, Your Lordship, to give the electricity supply of the glow sign boards. Paragraph 11 and paragraph 12, Your Lordship.
1 minute, just give us up. What were the notices regarding?
The notices, Your Lordship, regarding the threat of termination. Before termination, Your Lordship, we have given Your Lordship the letters so that Your Lordship, in default, we can give a Lordship terminated.
Right.
But Your Lordship, the trial court, Your Lordship, state the effect of the those particular notices. Your Lordship, may I just state the brief facts, very short facts, Your Lordship.
Calcutta granted stay of the notices.
Stay on the operation of the notices.
By the notices, they wanted to evict you.
No, Your Lordship. By the notices, Your Lordship, we wanted to terminate, Your Lordship, the agreement executed between us via the association.
You wanted to terminate?
Yes, Your Lordship. That the intention to terminate.
Just give us the background.
May I just make this. What happened, Your Lordship? We are the association of certain shop rooms. Your Lordship, in Obishar Mall is just, Your Lordship, adjacent to that EM bypass. He is one of, Your Lordship, the shop owner. Now, what happens, Your Lordship, that this particular arrangement is the shop owner first has to execute a lease deed with the main owner, and with the association, Your Lordship, they execute a separate agreement regarding the installation of the glow sign boards. As it is a clinic, what happened, Your Lordship, they executed the agreement and installed, Your Lordship, one glow sign board. When we inspected that glow sign board, we found, Your Lordship, it is not properly stable and it may, Your Lordship, actually fall because it is not attached to the wall. So we give them notice that kindly install it properly. They found, Your Lordship, it is an expensive affair because there are many shops, Spencer's, Batas, they have installed it in the wall, but they are basically installed it, Your Lordship, on the basis of the clamps. If Your Lordship kindly sees those particular glow signboards,
yes,
page number 86.
86 we have seen.
And it is, Your Lordship, kindly sees, Your Lordship, it is attached, Your Lordship, on 4 clamps.
Yes, right.
And we found, Your Lordship, if this particular glow signboard falls, then, Your Lordship, it will endanger to the human life.
Yes.
Now, if Your Lordship kindly sees other glow signboards are there, Your Lordship, kindly take page 89. These are the various glow signboards where the Bata, Your Lordship, kindly sees. And this was the page number 87, Your Lordship, is the earlier glow sign board which they installed. And it was attached to the wall. Page 87. The problematic, Your Lordship, is the 86. Now, when we gave them a notice, Your Lordship, that unless and until you do it, it will be in danger to human life. They filed a suit and got a stay order. Your Lordship kindly sees this particular order.
What did you say in the notices? What threat did you issue in the notices?
Lordship, note that there is an agreement, and if you don't actually affix that particular glow sign board on the wall, then we will take steps for the termination of the agreement which has been executed by me and you, and we will disconnect the electricity. On that basis, Your Lordship, they have gone to the trial court, has obtained an order of injunction. I was expecting the other side so that I can, Your Lordship, propose That the entire problem, your lordship, is that if can
Yes,
affix on the wall, either they will do it or we will do it and they will reimburse it. The matter will be ended.
Right.
Because glow signboard is required for their business and safety is required, because if anything happens, your lordship, the association, the president will suffer, your lordship. Everything will come on.
So
their
we
shoulder.
lifted the injunction on that on those notices. You can proceed with the notices.
I can proceed with the notice.
That was
but
our order.
That is, yeah, that
We
is
gave
the
stay of
problem.
operation of the order to the extent that you are restrained from giving effect to the notices. So
Gotcha.
now you can give effect to the notices.
We can give effect,
But
your
you cannot
lordship has-
disconnect the electricity
Yes, your
supply.
lordship. That is simultaneously, your lordship has given the order and we have complied with that order.
What have you done?
We have given electricity, your lordship. We asked them, your lordship, regarding the wires and everything. They have given and we have given the electricity. Now the problem is, if this particular glow signboard falls, your lordship, that will actually, your lordship, cause injury to, your lordship, the public at large.
If they
will
don't
come.
appear, what can we do, Mr.?
May I suggest, your lordship, if your lordship kindly expedite the injunction hearing, and your lordship, this particular stay order may be operative, your lordship, till the
We cannot
disposal-
dispose of the appeal because today the application is appearing.
Yes, your lordship. Then should I give another notice to the other side and
So
then
we will
come
do this. We'll dispose of the application. We'll extend this order till disposal of the appeal.
Lordship.
We'll dispense with the. You have to serve notice. Put in the postal cost for service of notice on then.
Lordship.
But trial court records you can dispense with, and you prepare informal paper books within 6 weeks on the basis of the papers you have.
My humble submission is little bit earlier regarding, because that glow signboard, if falls, your lordship,
How soon can you prepare your informal paper?
I'll file it, your lordship, within 2 weeks. I can complete everything.
But unless the notice is served on them,
I will serve the notice also.
the notice has to be served through court, postal cost.
Lordship, may I request only, lordship, kindly don't dispose of the stay application. Let me serve another notice, because if my proposal is accepted by the other side, this entire problem will be
Affidavit of service filed today be kept on record. Full Learned counsel for the appellant suggests that the entire problem, the entire issue between the parties is the fixation of certain glow signboards by the plaintiff's respondents by clamps instead of affixing them to the wall like the others, which endangers the life and limb of the people in the area. Next para, it is submitted that in the event the respondents appear in the matter, a mutual solution may be arrived at between the parties. However, unfortunately, although service has been duly effected, none appears for the respondents. Accordingly, it is prayed for by learned counsel for the appellant that in order to explore possibilities of a mutual conciliation, another notice may be directed to be served to ensure the appearance of the respondents. Next para. Hence, the appellant stroke petitioner shall serve further copies of the application to the respondents directly and stroke or through their learned advocate appearing in the trial court, indicating that the application shall next be listed on July 14, 2025, when a fresh affidavit of service shall be filed. Next para, it is made clear that nothing in the above order shall prevent the parties from entering into an amicable solution to the dispute. In the meantime, the interim order granted earlier is extended till disposal of the application.
I'm grateful.
So you can approach them directly for the mutual conciliation in the trial court also, and you serve on the advocate as well as the.
I'll do it, your lordship. The learned advocate who is appearing before.
Yes,
the trial.
in the trial court for them. But try to arrive at a mutual settlement. In the meantime, you can also do that.
Lordship,
Nothing prevents you.
Yes, sir.
My lord, item number 30, we are led by Mr. Mukherjee.
Mr. Mukherjee means?
Mr. Sobhasachi, he is appearing online.
He is appearing online? Yes.
Lordship, I am under compulsion to appear before your lordship online due to my physical illness.
All right. No difficulty. What is the appeal about? You are for the caveat. You have filed only one copy of each of the applications. Why?
Lordship, actually, lordship, the matter went to the
Memorandum.
honorable single bench, lordship.
Not his fault.
Yes?
My lord, it's not his fault.
Lordship, the matter went to the Honorable Single Bench Lordship, because Lordship, the matter was admitted. But Lordship, His Lordship, Honorable Justice Rajiv Sharma pointed out that at the time of admission, the no law point was framed. Due to that very reason, again the matter has been sent to the Honorable Division Bench.
But originally there had to be 2 copies of the memorandum at least.
Lordship.
Xerox copy দিয়েছে।
Lordship, in that event, Lordship, kindly give us a leave to file another copy of the paper book.
চালিয়ে নেবেন না, বা আপনি এটাও নিতে পারেন, আমি রিভার্স করব।
Lord, there's a division bench judgment which says that even if Lord,
Use the microphone so that we can hear.
even if the substantial question of law has not been framed, it's open for the single bench to frame it before
For the first time, we don't agree with that.
Justice Mantha's division bench.
We'll differ with that.
Lord,
Cannot.
I'll-
Under Order 42
I
Rule 2,
want it to-
cite that.
I'll cite it. Lord,
Order 42 Rule 2 is there.
Absolutely.
Very clear.
I bow down. But it's there, my lord. I'll bring it.
Let us formulate the questions instead of going to. What are the questions? Yes, you formulate the questions for them.
Lordship, the law points are Lordship. First thing is that Lordship,
It's a judgment of reversal or what? Give us the basic facts.
Affirmance.
Affirmance.
Lordship, in the suit court, in the learned trial court, we were defendant, Lordship. The suit for declaration, recovery of khas possession, eviction, and permanent injunction. In Lordship, the suit was decreed in favor of the plaintiff.
Khas
And
possession
Lordship,
on the premise that you were a trespasser.
actually, Lordship, in the plaint, it is written that we are the trespasser.
Yes, then
Then, Lordship, the suit was decreed in favor of the plaintiff. After that, we preferred an appeal, that is the first appeal. First appeal was also decreed in favor of the respondent plaintiff. And against this the order of the first appellate court, we preferred the second appeal. In the second appeal, Lordship, stay order was passed in our favor. Stay order was passed.
what is the substantial question of law, Mr. Mukherjee?
A substantial question of law, Lordship, the 5 points subject to Lordship's correction, I am placing these the points. Lordship, one vital issue has not been discussed in the decree of the trial court, that is, when the plaintiff filed the suit, at that time she didn't have any locus standi, because at that time she didn't have any property at all. The suit property, the schedule of the property is 10 kata land, but 10 kata land was not her property. In the year of 1962, she sold out the entire land. She sold out the entire land. At that time, she didn't have any locus standi to file this suit. This is one. Number 2 is, Lordship,
Where is
section 20
what is the date of the admission order, Mr.
It's right at the end in the paper book.
Paper book is there?
Yes.
Paper book কোথায়? Paper book আছে বলছে?
Yes,
August
I have the copy
27.
of the paper book, Lordship.
August 27, 1993.
Oh, Baba. So the plaintiff did not have locus standi?
No, Lordship.
And what else? How do we get that?
Pardon?
How do we get that? It's a question of fact.
And Lordship, second question, second point of law, Lordship. Second point of law is section 21, subsection 1 of Limitation Act.
What does it say? দেখি section 20 limitation act দেখি।
Lordship, kindly come to internal page number 7 of the judgment of the
চলে
first
গেল।
appellate forum.
ওদিকে ওদিকে
In 1993, this law was not followed too much. When it was
Yes, that we saw the names. That's why. 21-1, yes.
Lordship, kindly come to pay, Lordship, and 21 subsection 1, and Lordship, kindly come to page number 7, internal page number 7 of the judgment passed by Honorable First Appellate Court. Line number 4 from bottom.
Line number
4 from bottom. From bottom. May I read, Lordship?
1 minute, 1 minute, 1 minute. Internal page is not mentioned.
Page number 7.
Internal pages are not mentioned. It's a continuous typed copy. Probably this is the second judge's copy and another copy was given. টানা টাইপ করেছে তখন টানা টাইপ করে দিতে বলে কোনো জাজমেন্টই নেই এটা application of the paper. No, we don't have complete copy of the. Please file complete copies, both judges' copies, at least of the memorandum.
Lordship. But Lordship, memorandum, Lordship, this is a very old appeal. Lordship, as per my knowledge, Lordship, memorandum of appeal was filed, Lordship.
Paper book কোথা থেকে আনেন in paper book?
And paper book was also filed.
It is submitted by learned counsel for both sides that paper books have already been filed. Full stop. It is further contended that although the appeal was admitted long back, comma, since there was an observation by a subsequent bench of a learned single judge of this court that no substantial question of law was formulated at the time of such admission, comma, the appeal, the said questions ought to be formulated, comma, the matter has been mentioned before us. Full stop. At the time of hearing under Order 41 Rule 11 afresh, comma, we do not find all the necessary papers, comma, including the second judge's copy of the memorandum of appeal, full stop. Since counsel submit that paper books have already been filed, comma, which must contain all the relevant papers, including the memorandum of appeal and the judgments and decrees of both the courts below, comma, we direct the paper books to be tagged along with the appeal. Full stop. Let the matter be listed next on June 30, 2025 under the same heading. Paper books এর মধ্যে আনেনি।
Lordship, may I take one indulgence, Lordship?
সেকেন্ড জাজেস কপি তো নেই, তাতে তো কোনো ইয়েই নেই। ওটা শুধু রয়েছে, জাজমেন্ট গুলো নেই।
Lord, I usually don't pray for Lord any 30th June, Lord, I am in both play. First
July, তাহলে 30th না করে July 1, 1st July 2025. Mr. Mukherjee, please ensure that all the.
Lordship, after 7 July, Lordship.
Why after 7 July?
Lordship, from 1st July to 5th July, I will not be available, Lordship.
রিটার্নেবল ডেট যেটা বললাম ওটা July 8 করে দিন, 8th July 2025.
I'm deeply obliged, Lordship. I'm deeply
Please
obliged.
ensure that all the documents are filed in the meantime. You can mention before us and file the documents. We'll tag it with the main file.
Lordship.
Grateful to you.
If you have copies of the paper book, you can just photocopy and give 2 photocopies to us. We'll manage with that.
Lordship, we will give the photocopy to the department, Lordship.
No, to us.
Lordship.
Department, it will take another year then. Yes. Which matter is this? 31, who is appearing? Mr. Das, come forward. Yes.
Plaintiff is the appellant before my lord.
Mr. Das, please take the microphone a bit closer to you. Or you take yourself a bit closer to the microphone.
Plaintiff is,
Microphone is bent like that.
well, plaintiff is the appellant before my lord. Well, suit for declaration of title and right title and interest and injunction. Well, judgment of reversal. Well, what happens, Malad, that the original owner, Malad, of the suit property who obtained by way of deed of gift transferred to me by a registered deed of gift. From that, there, Malad, I
Original owner got by a gift.
who got the property by way of gift.
He also gifted to you.
My lord.
All right.
Now, what happens, my lord? These after we are in possession after that execution of the deed of gift.
Yes.
Subsequently, the person who made that deed of gift, he transferred to the original owner by a register another deed, and he
1 minute. A transferred. A was the original owner. He transferred to B. B transferred to you.
Lokhi was one. Lokhi Devi was the original owner. Well, he transferred. She transferred, my lord, half shop,
half shatak,
three plots, half to the one Shukesh, another half
to
one Shukesh Jana.
Shukesh
Jana, well, adopted son, and another part to his daughter, to her daughter.
Demarcated parts.
Yes. We are in possession. Accordingly, the parties are in possession. Now,
But do you come in?
And Shukesh, well, who got this property, he transferred by a registered deed of gift to me. I am the plaintiff before my lord. Now, this Shukesh, after 3 years or 4 years afterwards, he transferred the plot of land to this original daughter, to this original owner.
Lokhi.
Yes, Lokhi.
Transferred back.
Transferred back. This Lokhi transferred the case plot to the present defendant before my lord. The question is, when my deed is executed earlier one, and also your lordship.
Your deed was registered earlier?
My lord.
Gift deed.
Gift deed.
So how did the appeal court reverse?
Appeal court reverse that since after the execution of the deed gift, you are not in possession, therefore that deed is to be given to me.
So 122.
122 and 123. Now the question is, my lord, whether the actual delivery of possession is required or not. In the deed itself written that I am delivering the possession, you from today you pay the tax, all the earlier tax receipt has been handed over to me. The trial court
You never took possession.
No, I am in possession.
So
Trial court held.
How did the appeal court reverse it? Show us the reversal portion. Appeal court. Must be some reason.
Well, kindly see page 16. Well, the recital from middle portion.
Yes.
The recital in the deed that Shukesh was issueless has been proved to be false in view of the oral evidence on the record. Thus, in view of this peculiar relationship, the decision of Madras High Court cannot be accepted. As per section 122 of the Transfer of Property Act, gift must be accepted by the donees. What the law requires is acceptance of gift after it is executed, though the deed may not be registered. The acceptance may be implied, but there must be positive conduct of the donee or anyone accepting on this behalf. This implied acceptance cannot be extended to that English law. The decision on this point reported in such as a.
What is the was it the case of the defendants that there was no handing over possession? They said deed of gift was enacted upon.
Yes. And Mother, kindly see the maybe wrong. Kindly see the judgment of this Supreme Court 3-page judgment.
So first, let us see this judgment, complete this judgment on the ground.
Though my deed is executed earlier one, on earlier
No,
one.
deed execution itself is not sufficient in case of a deed of gift. Sections 122, 123 come in.
Yes.
You have to show that it was accepted during the lifetime of the donor.
That from that your lordship will get it. That your lordship will kindly come to kindly see page 11 of the judgment of the trial court.
You said you collected rents from tenants but failed to produce any rent receipt.
No. I paid. Kindly see Exhibit 4 core. Exhibit 4 core, my lord, that is been.
These are
Well, kindly see
Khajna
page
Dakhilas.
11.
These
Yes.
are Khajna Dakhila, not
Khajna Dakhilas.
in respect of
Kindly
this.
see Page 11, my
No,
lord.
no, those were by Lokhi Devi and Sukesh.
No, those were,
Yes, page 7 of the trial court.
kindly see page
Lokhi
11.
Devi Sahu Sukesh Ranjan Jana Diyot Khajna Dakhila. Page 7 of the trial court, which was in your favor. Please come to page 7 of the trial court. Fourth last line from the bottom. Fourth line from the bottom. Lokhi Devi Sahu Sukesh Ranjan Jana Diyot Khajna Dakhila.
সুকেশ হলো
Therefore, it was not by you.
প্রমাণ রেখেছেন এবং বাদী দিয়ত খাজনা দাখিলা প্রদর্শ 4 ক ইংরেজি 4/8/96 প্রদর্শন 4 গ প্রমাণে সাক্ষ্য হিসেবে প্রমাণ করিয়াছেন। Have you lost got it?
Let us see how the trial court dealt. Trial court is at page 10.
Page 11 your lordship is the relevant portion.
Page 10, yes. এই একটু ট্রান্সফার প্রপার্টি একটা দেবেন?
Well, I have got.
You have got one copy. We require 2 copies. Thank you.
122 and 123. Your lordship will have to read this section co-jointly. Well, that is the and also the judgment of this Honorable Supreme Court. 3 major judgments. In the deed itself mentioned that for handing over possession.
In the deed of gift, Mr. Das, it was written that you have accepted.
Why not?
Have you annexed the deed of gift anywhere in your?
No, that is not annexed.
Where is the finding of the trial court in that regard?
Well, your lordship will kindly see page 11.
Page 11, we are there, trial court.
সম্পত্তি হস্তান্তর উক্ত 123 ধারা করিতেছে দানপত্র দলিল যদি আইন মোতাবেক সম্পাদিত হয় রেজিস্ট্রি হয় তা গ্রহীতা কর্তৃক গ্রহণ হয় তাহলে সম্পত্তি হস্তান্তর সম্পূর্ণ হইতেছে এই সেই ক্ষেত্রে সম্পত্তির দখল হস্তান্তর না হলে দান অসম্পূর্ণ হইতেছে না অর্থাৎ সম্পত্তি হস্তান্তর আইনে 123 ধারা মতো দানকৃত সম্পত্তির দখল হস্তান্তর না হইল যদি দাতা যদি উক্ত দলিল কর্তৃক সম্পাদন হয় এবং কমপক্ষে 2 জন সাক্ষী দ্বারা তা অ্যাটেস্টেড হয় এবং গ্রহীতা কর্তৃক দান যদি গৃহীত হয় তাহলে সম্পত্তি আইন মত সম্পূর্ণ হস্তান্তর হইতেছে এবং দান সম্পূর্ণ হইতেছে।
This second appeal, yes, not necessary. This second appeal will be heard on the following substantial question of law: whether the learned judge of the first appellate court substantially erred in law in reversing the decision of the learned trial court on the premise of the finding that delivery of possession of the suit property was not handed over to the appellant stroke donee, and as such the gift was not complete within the contemplation of section 122 of the Transfer Property Act, 1882, by overlooking the settled position of law that on a conjoint reading of sections 122 and 123 of the said act, if the transfer is effected by dint of a registered instrument and the deed itself records that the donor, pursuant to the said gift, was handing over all title deeds and necessary documents to the donee, and the donee was accepting the same, there would be no further necessity to prove delivery of possession for completion of the gift deed under sections 122 and 123 of the said act. Only this question. Any
application for injunction has been made, but direct me to serve.
The appellant stroke stay under injunction. What sort of injunction?
The injunction not to transfer and also not stay of the operation of this judgment.
stay of operation does not mean anything. Then your decree will be revived. We won't grant that. We'll grant injunction. The appellant shall serve a copy of Can 2 of 2025 on the respondent, indicating that the application shall be listed before the appropriate learned single judge having determination as and when the time limits for filing affidavits as stipulated by us is over, and shall file an affidavit of service on the date of final hearing of the stay application. Full stop. Next para. The respondent shall file affidavit in opposition, comma, if any, to the application within July 4, 2025. Reply, if any, shall be filed by July 11, 2025. Full stop. Next para. The respondent stroke opposite party and stroke or her men and agents shall remain restrained by an order of injunction from selling, transferring, alienating and or encumbering the suit property in favor of any third party and or changing the nature and character of the same during the pendency of the application. Full stop. Both parties shall maintain status quo regarding possession in respect of the suit property also till disposal of the application.
Another thing, my lord, lower court record may be brought by special messenger. I shall deposit.
The appellant shall put in due requisites and postal costs for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Grateful.
Thank you. Great. Next. Delivery of possession necessary not. বডিতে লেখা ছিল যে ট্রায়াল কোর্ট ফাইন্ডিং আছে।
And for the appellant, my lord, certain defects are there. My lord.
What defect? Your appeal, your defects, so you have to remove. Why didn't you remove till now?
I
Why didn't you remove till now?
shall rectify, my lord.
Pardon? Can't hear you. We use the microphone.
I shall rectify my defect, my lord. The transfer be, my lord.
Rectify by tomorrow. Rectify by tomorrow. We'll take it up day after tomorrow.
Liberty may be given, my lord.
We are giving liberty. You will rectify by tomorrow. We'll take up day after tomorrow. But one person has executed Vakalatnama in spite of not being a party, Rita Nandi.
I do not know, my lord, the matter.
You check up.
Subhash Chandra Atta appearing this matter, my lord. I do not know. I am not advocate record, my lord.
Where is he?
They engage another court, my lord.
The appellant is directed to remove the defects by June 27, 2025. The appeal shall be listed under the same heading on June 30, 2025. By Friday, remove the defects. Try to do it by tomorrow itself.
The defect that has been shown, my lord, that discrepancy in the date of judgment and decree, my lord, that and the name of the learned judge, my lord, of
The
the trial court.
discrepancy, what discrepancy?
My lord, it has been drawn into different dates, my lord. Your lordship knows the decree should bears the same date of that than that of judgment.
Erroneous date of decree of the trial court. No, in the preamble.
Preamble, my lord, the name of the learned judge has not been mentioned. Kindly give me leave,
No,
my lord.
not that. It said that you have mentioned the decree date and judgment date differently in the preamble itself.
Yes, my lord, that could not.
So you score through the decree.
Yes, yes. My lord, that
And
should bear, my lord, the same date.
And judgment, after judgment, you put in and decree. You have a copy of the memo.
Yes, my lord.
Just look at the preamble, Mr. Mukherjee. After judgment, you put in and decree dated such and such.
Yes, yes.
And you score through the decree dated August.
1st August, yes.
So do that. We'll give you that leave. And what else?
And the name of the learned judge of the trial court is not been mentioned.
You will do that. No, it's there. Name of the
But
trial
that is
court.
not the appellate court.
Oh, the trial judge.
Trial court. Trial judge is.
And the other defect,
আরো ডিফেক্ট ছিল তুই দেখিস ঠিক আছে
না ওটা সেন্ড ডাউন করতে বলেছে ডিগ্রির জন্য ডিগ্রি
For the other defects, it has to be sent down.
সেন্ড দাও
Very well. Leave is granted to the learned advocate on record for the appellant to carry out the necessary rectifications in the preamble by introducing the name of the learned trial judge as well as by scoring through the superfluous date of decree, comma, in terms of the defects as pointed out by the stamp reporter. Full stop. Insofar as the correction of the decree of both the courts below is concerned, comma, the file shall be the said decrees shall be sent down for necessary corrections at the earliest. Full stop. The appeal is now taken up for hearing under Order 14 Rule 11 of the court. You will carry out the rectification. Your junior will carry out by today.
by today.
Yes. What is the matter?
The suit initiated after giving notice under section 6 of the West Bengal Premises Tenancy Act, treating the defendants to be premises tenant. In such a suit, subsequently,
Yes.
amendment was brought in, keeping alive the original statement made in the plaint, subsequent ground of 2G. So, may I just, and that has been allowed by both. The suit is decreed, my appeal fails.
Which 2G is by operation of law.
I am coming, by operation of law, but under section 2G, it has been mentioned that there can be a fresh tenancy.
Fresh tenancy, of course.
Yes. So,
you made out a case of fresh tenancy.
The plaint itself, may I just hand over the original plaint and amended plaint both.
You haven't annexed those.
In the stay application, this has not been done.
2 copies each.
I have made a compilation if your lordship takes it up. It's a case, classic case, which once your lordship has dealt with while deciding an application on Order 6 Rule 17 even, whether this can be done, because this is a case where it has not been spelled out who was the original tenant in the initial original plaint. Kindly takes up paragraph 2 of the original plaint. I have given the
first one is the original plaint.
First one is the original plaint.
Where is the amended plaint?
Amended plaint ওখানে নেই?
না ওটা WS আছে
Oh,
এটা amended plaint আর
Let's-
amended WS
Amended plaint and WS is here. If your lordship takes up paragraph 2 of the original plaint,
Yes.
it remains in the amended plaint also intact, that until determination of tenancy, we have to bear on mind, as per their amended case, the original tenant died sometime in 2011. This is a suit initiated in the year 2014, when his wife and the children who has been arraigned as defendant number 1 to 5. Kindly takes up now paragraph 2, that until determination of tenancy, the defendants were a monthly tenant in respect of the suit property at a monthly rental of ₹100 per month.
Eviction notice was given on you, all of you.
Yes. It's positive statement. It has addressed to all, sent to one, to all the defendants. And it remains intact, even in amendment. I could have understood that this portion has been scrolled out. So, at a rent.
There's a case of fresh tenancy, Mr. Mukherjee.
That is there in the
There cannot be
plaint.
any admission against the law.
No, I am not on that.
They say you are monthly tenants, but
Where, in one of the judgment, division bench, this has been stated, there can be estoppel against the law. But the law does not debar that a fresh tenancy cannot be
yes, but
created.
there has to be a case made out in the plaint.
In the plaint, I say, in the plaint
This is
itself.
not a case of fresh tenancy.
But he is saying that defendants are the premises tenant. Kindly, it's a positive statement of the plaintiff. Admission need not be proved. It's a positive case of the plaintiff that defendants are the premises tenant until determination of tenancy at a monthly rental of ₹100, and they prayed eviction on the ground of default.
What was introduced against you in the amended
Yes,
plaint?
Amended
They
plaint,
introduced 2G.
2G.
Let us see that portion.
Yes, kindly takes up the amended plaint once.
Yes.
The initial, all the statement, including the notice point and default, that was taken, that was remain intact. What they have incorporated, if your lordship takes up internal page 6 of the amended plaint.
They say until determination.
Yes, determination is by way of giving notice under section 6.
They have not said that.
Milord, that is Milord I shall place
Why
the
can't it be by operation of
entirety of paragraph 2, if I may read, Milord. Entirety of the paragraph 2, they are suggesting that until determination of notice under section 6.4. And 6.4, they have
this may mean until determination may mean until determination by operation of 2G also.
That's why, Milord, may I take, Milord, to your Lordship, Milord, the statement made in paragraph 2 as well as, Milord, yes, paragraph 2 once, Milord, may I place, Milord. It's important. Payable according to English calendar month governed under West Bengal.
Yes, said tenancies to determine by
Yes,
6.
yes. It connotes, Milord, if this, Milord, something, Milord, 2G, perhaps, Milord, this is a provision which has not been looked into, Milord, in the initial stage after 1997 Act came into force. There are many suits. But this is something which is spelled out by the plaintiff that I am a premises tenant, my tenancy has been terminated by giving notice under section 6.4. This positive statement remains. And there is no debarment, Milord, under section 6, under section 2G, that fresh tenancy cannot
There is
be.
a case of fresh tenancy.
Yes.
They said the previous tenancy continued, which is erroneous in law. They said as per them until determination the tenancy continued. There is no case of fresh tenancy being.
Milord, once, Milord, kindly consider, once they are treating me as a tenant under him, giving me notice under section 6, not only, Milord, to the wife, I could have understood.
That was superfluous. By operation of law, you have lost your status
Milord,
as a
by
tenant.
operation, Milord, by operation of law, rider is, Milord, subject to, Milord, the landlord or tenant, a fresh tenancy is being created. And if by the
There is no case of fresh tenancy creation by any of the parties. They say the previous tenancy continues until notice of
subject to correction, Milord, had it been a case of the original plaint, that no, my original tenant is such and such, and thereafter you become a tenant, then it could have been understood that yes, the tenancy is flowing from the predecessor.
They say
have
that until determination, the defendants were
no, Milord, their case is starting from paragraph 2, the tenants is defendants.
Have they stated about the previous tenancy?
No, in the original plaint, nowhere. That's where your Lordship's judgment come into force. Your Lordship make a distinction that if a case is started from the previous one and thereafter it has been flown down. But that was the case where your Lordships interfere. There also, the case was made out.
There is the mention of the original.
In the original plaint, nothing. They started that
the 6.4 notice starts with you.
Me and other as well as other defendants.
The 6.4 notice was given in 2014 itself or 2013.
Milord,
After
they have
demise of
given
the original
May 2014. Yes. There lies I am on. And Milord, the learned judge, Milord, have in one of the places.
যদি ওর কেস হতো অরিজিনাল তার মারা যাওয়ার পর এটা কন্টিনিউ করবে তাহলে এগেইনস্ট দ্য ল ও কেসটা শুরুই করছে আগে অরিজিনাল কথা বললেই না শুরু করছে 11ই মারা গেছে 2014 নোটিশ দিল এদের টেনেন্ট গুলো এবং এভিকশন স্যুট ফাইল করলো শুধু এদের বললো না যে ওর মারা যাওয়ার পর হয়েছে ফার্স্ট টাইম টেনেন্সি অ্যাডমিট করে করছে তাহলে তো 2G কনসেপ্টই আসছে না কেন এরা কেউ মারা গেলে তখন where is the case of 2G in the let us see how the
page 6 of the amended plaint, Milord, Roman point 3 onwards, Milord.
There they say about the predecessor and all.
Yes, but Milord, kindly consider by 7172 by the Milord defendants that has been considered and disposed of after that period of 5 years over, and the learned judge is giving me protection under section Milord 71 and 72 because the one of the ground pleaded in the plaint is that default till date. So I say, Milord, it's a fresh tenancy created by the pleading made in the plaint.
But after the amendment, the pleading was introduced.
Pleading was introduced, Milord, keeping alive the original statement remains in the plaint.
Even if the original statement remains, Mr. Mukherjee.
Milord,
now they say that
if I admit once that you are a tenant under me, can I go back and say, no, you are no more a tenant? Because I say 2G is not an absolute bar. 2G say if no contractual relationship subsists subsequently, so automatically I cannot inherit the tenancy. But here is a case made out in the plaint wherein he accepts me as a tenant.
Can we proceed on the basis of the original plaint after the plaint was amended?
I say, Milord, both, Milord, your Lordship kindly consider it's a plaint. Contradictory, self-destructive pleadings. may be permitted to be taken in the written statement, but it is the plaintiff who has to succeed in his plaint.
Did you challenge the plaint amendment order?
No, today I can, my lord, before your lordship
No, if
also.
you did not challenge, then you can.
Yes, I
That
need.
is what
I
why
have
you
not.
were
I
asking.
have not. I have not. That is one of the
Challenge. Go to the High Court.
challenge. Oh, I mean,
Dismissed.
that
Revision
I was-
dismissed.
Then, my lord. Then also, my lord, I say, if it's a self-destructive statement, I could have understood that in a defense, the defendant can always, two ways of, my lord, defense he can set up. But if the plaintiff keeping alive his original statement on board, he stated that yes, now this has been done 2G. 2G is something which is available
Let's
to
see Roman 3 at page 6.
Yes, my
Please
lord.
read it out, Mr.
Yes, my lord.
Mukherjee.
Yes, my lord. The plaintiff state that the defendants candidly admitted that Kalipodo Pal was the original tenant inducted by the landlord, and the Kalipodo Pal expired on 10th of April 2011. And the defendant filed a suit, title suit number 15 of 2014, and prayed for passing a decree for permanent injunction as set out in the prayer of the said plaint, praying order of restraint from interfering any way the physical possession of the plaintiffs and or from disturbing in any way the common use bathroom, toilet and water in the premises number such and such, and the defendant candidly stated in course of paragraph 6 of the plaint that the predecessor of the plaintiffs, Kalipodo Pal, expired on 10th of April 2011, but it has been wrongly stated in paragraph that after the death of original parent Kalipodo Pal, all right and interest and possession of the suit property had been devolved upon the defendants who are wives, sons and daughters of the deceased tenant Kalipodo Pal, because new act of 1997 protects the heirs of the deceased tenant for a period of 5 years from the date of death of the tenant, and the phrase 5 years inserted to give limited protection to the heirs of the tenant, and section 2G of the Act 1997 makes a departure from section 2H of 1956 Act and will govern in the definition of tenant after the 1997 Act has come into effect, and only a person claiming tenant comforts the definition of 2G of the Act will be regarded as a tenant, and the object and intention of 2G of 1997
Mr. Mukherjee, in your
now
plaint, you have admitted that has been shared.
today, I am not banking upon my case. 2G is a window available to them. Once they have admitted, it's the plaintiff has to,
not merely window, it's
2G is
substantive.
something,
Substantive.
2G, yes, substantive.
It's a very
I cannot
status.
claim inheritance. I say, I bow down before your lordship. But can it be not be
There is
happen
no
that
case of fresh tenancy even in your plaint.
not in my plaint. It is their plaint.
Your plaint has been quoted here.
My plaint, it's wrongly written. It has to be, I have given my written statement before your lordship.
No, title suit number 15 of 2014 was filed by you. That has been stated in page 6. Page 6 states about a suit filed by you where you admitted your predecessor was the original tenant. And you claim through them.
It is nobody's case that my predecessor is not the original tenant.
You claim through them.
But in their suit, they have stated me to be a defendant and me to be his tenant under him, without giving
That's an admission against the law, Mr.
Again, I am try to explain.
If this amendment was not there and if your challenge, if this amendment was not there and if your challenge to this did not fail,
may I say,
Mr. Ghosh, have you got anything to show that their challenge failed to this amendment order? Have you got any detail, any number, anything?
Yes.
Show us that order. If that challenge was open, we could have considered it. But if the challenge failed,
in my respectful submission,
This is the order of the trial.
I am not standing.
Order of the trial.
My case is not that this is an estoppel against statute. Again, I am submitting, respectfully before your lordship. No, there cannot be any estoppel against this statute. I am not saying that. 2G, yes, 2G is there. I cannot.
After the amendment, now the plaint case
has been explained. I may say it has been explained. Yes, I am on.
Not contradiction, not
Even
mutually
if, destructive. Why? Because once, while filing the suit, he may say, there are classes of cases where, they are saying, yes, you are there, your 5 years has not elapsed, but I am filing the suit. But here is a case where he has.
Proceedings have merged after the amendment.
Merger is something, but once it is an admission that you are a tenant under me, can he go back and say, because his case is starting from the defendants? Again, I am saying that there are two differences on that than that of that division bench. Here, the case started with the defendants. They have not made out anything. It is nobody's case that my predecessor was not the tenant. But there cannot be a situation where after the death of my predecessor, he can accept me as a tenant. And he has done so. He has done so. He has accepted me as a tenant. He filed a suit giving notice under section 6(4), taking a ground of default, reasonable requirement. If this is not a conduct, not estoppel by conduct, I am not saying 2G will attract. I cannot be tenant by inheritance, but I can be tenant by conduct. Because a contractual relationship subsists between the parties, and one party, who is the landlord, he accepts me as a tenant. There lies an issue which I want to join. 2G. The amendment, subject to correction, the amendment, by virtue of the amendment, what he tried to incorporate. He tried to incorporate the change of definition of 2H and 2G. I bow down. I cannot come under the definition of 2H.
No, more importantly, he incorporated that you have become tenants after the demise of your predecessor.
I become a tenant after demise of my predecessor. It is nobody's case that yes, I become a tenant after demise of my predecessor. And this can be done, according to the law. 2G is not a bar that the landlord never accepted the legal heirs of the original tenant who died after 1997.
Have you got a copy of 97 Act?
Yes,
Premises Tenancy Act 97 টা দিন তো।
97. আমার Premises Tenancy Act কোথায় গেল?
Thank you.
এটা দেখি।
Right of preference of tenancy in a fresh agreement. You have a right of preference if a fresh tenancy is given. That is not the case of anybody, neither of you.
So 2G is not a bar that legal heirs, in respect of the legal heirs
There is
of
no
the
bar. 2G is not.
And why?
Fresh tenancy can be created.
But that is
There is nobody. It is nobody's case that a fresh tenancy is created.
That's no, they are saying that you are a tenant under me as per rental of such and such. And
if they had stated that a fresh tenancy was created in the original plan, there would be, it would militate against each other.
The question remains, once they are admitting me as a tenant, the question, it has to be 2H and 2G. I am not standing in the A. 2H, I cannot claim benefit of 2H. I will come under 2G. But after this positive statement in the plan, wherein he is saying that you are a tenant under me, I am giving notice of termination of tenancy under section 6. And after the expiration of that, you become a trespasser. So, the question that then, the 2G says, there is no question of giving, any notice under section 6.
That is superfluous.
I will say, yes, that is superfluous. That will coupled with a
that will not be under section 6.
That will coupled with a pleading that you are a tenant under me. I am terminating your tenancy. You are a defaulter. I require my premises reasonable requirement, and you are a defaulter till date. Kindly see,
how did the courts dealt with this point?
This point, this aspect has never been dealt with.
Did you argue this aspect?
No,
surely not.
That, it's a question of law, I can argue before your lordship. This is something, 2G, it needs to be gone into, there are 2 or 3 decisions of this honorable court, also, wherein this aspect of the matter has been dealt with, how the tenor of the plaint can be changed in such a fashion.
It has been changed. You challenge that order.
I bow down, but still, this statement remains in the plaint. 2G, what
will be interpreted.
What has been
Mr. Mukherjee, the plaint has to be read as a whole, right?
I bow down.
If the plaint has to be read as a whole, if they say in some portion of the plaint that you were tenants till determination, and in the other portion they say that that tenancy was derived from your predecessor for 5 years.
No, there I am joining an
so
issue.
We can reconcile.
Reconciliation, is something. The admission remains intact. Defendants to be the tenant, that admission remains intact. It is a brainchild. They have thought 2G incorporation.
No,
what amendment is being carried out, the amendment really is a legal nature. They say, my occupation become bad due to operation of law of 5 years. But they have forgotten that they have admitted me as a tenant. They sent me notices under section 6. They have pleaded default. I have taken protection under section 7(1) and 7(2). One of the one of the issues framed in the suit that whether I am a defaulter or not. It's really this exercise can be done. My lord, kindly see
The
section
other
6.
issues become socios after this.
My lord, section 6. My lord, section 6 operates if it is a suit initiated under the Premises Tenancy Act. Is any of the grounds mentioned under section 6? My lord, it's a suit initiated. It's under a special statute. My lord, kindly consider. 2G is under general law. This is not a suit under section Premises Tenancy Act. Section 6 suit is an application under a specified act. He has taken aid of that. He given me notice, pleaded default, pleaded reasonable requirement, inquiry done, issues frame, taken protection under section 6, 7.1 and 7.2. This was done after, my lord, 5 years. So this thing has been gone into. My lord, 2G, my lord, again I am submitting, my lord, with greatest, my lord, humility before your lordship, that 2G is something one has to make up his mind. Once admitting the present defendant to be tenant under him, pleading of default, section 6 suit initiation, it's not automatic, my lord. My lord, 2G is something by operation of law, I admit. I cannot, my lord, today also, by standing here, I cannot say my tenancy right has been inherited from my predecessor, because that goes, but that does not debar a tenancy to be created. And there is a positive statement. Initiation of suit under section 6. Otherwise, he will be outside the window of section 6. He pleaded blood default, invited the court, issues frame. I get protection under section 7. Once that exercise has been done, merely, this 2G is by operation of law. Even he has not pleaded in my respectful submission. He has not amended his plaint. Then also he can take this point. Had it been a case that his plaint is such. But today, once he is admitting that, starting the case is of the defendants itself. Look, you are my defendant. You are the defendant in the seat. You are the tenant under me. Last paid rent is such. You are a defaulter. I have given you notice under section 6.4. Once that notice is given, your possession became bad.
No, Mr. Mukherjee, sorry. You have tried your level, you have argued splendidly. We must say we were convinced, but almost convinced. We'll give our reasons. Certain very interesting questions have been raised in the present second appeal. Push up next para. The brief facts of the case are that the plaintiff stroke respondent filed one plaintiff. No, plaintiff stroke respondents filed a suit for recovery of possession against the present defendants appellants under section 6 of the West Bengal Premises Tenancy Act 1997 on several grounds as enumerated in the said statute. Push up in the plaint, comma, it was in the original plaint, comma, it was stated that until determination of the tenancy of the defendants by a quit notice under section 6 within bracket 4 of the 1997 Act, comma, they were monthly tenants. Subsequently, comma, by way of amendment of the plaint, comma, the plaintiffs stroke respondents introduced the fact that the predecessor in interest of the
this judgment paragraph 22 I want to read.
The predecessor in interest of the defendants, Kalipada Pal, comma, who was the original tenant in respect of the property, comma, expired on April 10, 2011. Full stop.
Paragraph কত বললো?
Next para, it has also been pleaded in the amended plaint that under section 2 within bracket small g of the 1997 Act, comma, the defendants stroke appellants lost their status as tenants and were rendered trespassers after 5 years from the date of demise of the original tenant, through whom the defendants claim their tenancy rights. Full stop. Next para. Both the courts below granted a decree of eviction on the ground that the defendants appellants were trespassers under section 2 within bracket small g of the 1997 Act. So next para. Learned counsel for the appellants argues that the frame, that as per the frame of the original suit as reflected from the initial plaint, comma, the defendants stroke appellants were monthly tenants under the 1997 Act in their independent right of tenancy and not as the heirs of the original tenant. Full stop. It is argued that by virtue of the amendment, comma, a diametrically contradictory plea of the plaintiffs, of the defendants being tenants through their predecessor in interest, comma, the original tenant, comma, was introduced. Full stop. Since the two pleadings militate against each other, comma, it is argued that the original pleading has to be taken as an admission that the defendants were monthly tenants in their own right. Full stop. It is submitted that as per the frame of the suit, as in terms of the original plaint, comma, in the absence of any reference to the tenancy being inherited, comma, it has to be construed that the plaintiffs admitted a fresh tenancy being granted to the defendants after the demise of their predecessor. For some next para, it is argued further that section 2 small g within bracket of the 1997 Act does not preclude a landlord from granting a fresh tenancy to the heirs of the original tenant. For some next para, it is next contended that relief was granted under section 7 within bracket 4 of the 7(2) read with 7 within bracket 4 of the 1997 Act to the defendants by construing them as tenants in respect of the property. Full of that apart, comma, the eviction notice under section 6 within bracket 4 of the 1997 Act, comma, which was the cause of action and the genesis of the suit itself, comma, itself admitted that the defendants stroke appellants were monthly tenants. Full stop. As such, comma, the plaintiffs stroke respondents could not resile from that position by the subsequent amendment. Full stop. Next para. Thus, comma, it is submitted that both the courts below substantially erred in law in proceeding on the premise that the defendants stroke appellants were trespassers under section 2 within bracket small g of the 1997 Act. Full stop. Learned counsel for the appellant cites a judgment of a learned single judge of this court in CO number 3022 of 2019, where it was held inter alia that the entire pleadings as discussed therein above, comma, of both sides, comma, proceeded on the premise that the defendants were original tenants as opposed to tenants in common by inheritance. Full stop. The plaint never averred, comma, in its original form, comma, that there was any devolution of tenancy on the defendants as tenants in common upon demise of the predecessor in interest of the defendants, comma, that is the original tenant. Full stop. Moreover, comma, the only instance when the defendants were described as trespassers in the plaint was on the premise that they did not comply with the quit notice under section 6 within bracket 4 of the 1997 Act. Full stop. No mention of section 2 within bracket small g was made in the plaint at all in the said case, comma, despite such plea being available even at the inception of the suit. Full stop. The suit itself was instituted in the said case in the year 2013 and the Act commenced long before such institution. Full stop. It was taken note of that the period of 5 years after commencement of the 1997 Act, comma, let alone from the demise of the erstwhile original tenant, comma, had elapsed much prior to the institution of the suit. Full stop. On such premise, comma, the court went on to hold that the plea of section 2 within bracket small g was not available to the landlords. Full stop. Next para. Upon a careful consideration of the arguments of the appellant, comma, we, however, are of the opinion that no substantial question of law is involved in the matter for the following reasons, colon, next para. Insofar as the frame of the original suit is concerned, comma, it is pointed out on query of court by learned counsel appearing for the respondent caveators that the order dated March 18, 2021 passed in the suit, comma, whereby the amendment, the application for amendment of the plaint was allowed, comma, was affirmed in revision by dint of the order dated November 22, 2021 in CO number 1514 of 2022, comma, how could it be, of 2021, comma, preferred at the instance of the defendant stroke appellants. Full stop. Next para. Thus, comma, 103 is it? Section 103, 105. Thus, comma, the principle laid down in section 105 within bracket 2 of the 105 within bracket 1 of the Code of Civil Procedure cannot be borrowed in the present case, comma, since the fate of the order allowing the amendment of the plaint has already been tested and affirmed by a learned single judge of this court. Full stop. Opening up the window of section 105 within bracket 1 of the code in a case where a challenge was preferred but turned down against the interlocutory order granting amendment of the plaint, comma, would be completely unjust and against the spirit and letter of law. Full stop. Next para. Thus, comma, we have to proceed on the premise that the amended plaint stood firm as on the date of passing of the impugned decree of the courts below. Full stop. Next para. It is well settled that the pleadings in a plaint has to be read as a whole and not in isolation. Full stop. Even if in the first part of the plaint, comma, in particular in paragraph number 2 thereof, comma, even after amendment, comma, the pleading remained that the defendants stroke appellants were monthly tenants in respect of the suit property till the quit notice under section 6 within bracket 4 was issued, comma, the same was watered down by the subsequent pleading in paragraph number 2 within bracket 3 within bracket small Roman 3 to the effect that the defendants, comma, in a suit previously filed by themselves, comma, had admitted that the predecessor in interest of the present defendants appellants, one Kalipada Paul, comma, the original tenant, comma, expired on April 10, 2011, and thereafter the tenancy rights of the said deceased Kalipada Paul devolved upon the present defendants appellants. Full stop. Thus, comma, from the pleadings of the amended plaint, comma, it can very well be gathered that the predecessor in interest of the defendants appellants, one Kalipada Paul, was the original tenant, and on his demise, the tenancy devolved on the present defendants. Full stop. Next para. This, comma, read in conjunction with the statement that the defendants were monthly tenants, comma, when construed together, comma, clearly indicates that the admission, that the so-called admission as regards monthly tenancy of the defendants was an admission against the law, comma, since by operation of section 2 within bracket small g of the 1997 Act, comma, in the backdrop of the fact that the tenancy, that on the demise of the original tenant Kalipada Paul in 2011, comma, his tenancy rights devolved on the present defendants as his heirs. Full stop. Next para. More importantly, comma, it is nobody's case, comma, in either the written state, in either the amended plaint or the written statement or additional written statement, that a fresh tenancy was created in favor of the defendants stroke appellants after the demise of their predecessor in interest, comma, the original tenant Kalipada Paul. Full stop. Thus, comma, The argument in that regard cannot be accepted at all. Full stop. Read in conjunction, comma, the pleadings of the amended plaint go on to show that the ingredients of section 2 within bracket small g of the 1997 Act were fully available, comma, as the defendants appellants claim to be tenants by virtue of their heirship of the original tenant on the latter apostrophe's demise. Full stop. Next para. Hence, comma, it cannot be said that the ingredients of section 2 within bracket small g were alien to the pleadings in the suit. Full stop. Next para. Insofar as the question raised regarding the frame of the suit being under a special statute, that is the 1997 Act, comma, we find from a perusal of the plaint that the relief sought therein was ultimately recovery of possession of the suit property from the defendants stroke appellants. Full stop. Next para. It has to be kept in mind that that section 6 of the 1997 Act, comma, which is couched in a negative language, provides that no order or decree for the recovery of possession of any premises shall be made in favor of the landlord against the tenant unless the grounds set out therein were satisfied. Full stop. It is noteworthy that the expression double inverted civil judge double inverted clause has been mentioned therein. Full stop. The said expression clearly denotes that the forum before which a suit for eviction under section 6 of the 1997 Act is to be filed is not a persona designator but acts as a civil court, as in within double inverted civil judge. Full stop. Next para. Therefore, comma, at the end of the day, comma, the suit filed in the present case was an eviction suit filed before a learned civil judge who otherwise had jurisdiction to take up a suit for eviction of a trespasser as well. Full stop. Next para. In the present case, comma, the notice under section 6 within bracket 4 was evidently superfluous. Full stop. The statement made therein and in the original plaint regarding the defendants being monthly tenants was clearly an admission against this statute and as such cannot be given much credence to. Full stop. Next para. The next argument of the appellants that an adjudication was made under section 7 within bracket 2 granting relief under the said subsection and subsection 4 of section 7 to the appellants, comma, do not automatically determine conclusively the rights of the defendants appellants as tenants. Full stop. As well settled, comma, interlocutory orders cannot bind the court while passing a final decree on taking evidence. Full stop. It cannot be gainsaid that the order passed under section 7 within bracket 2 was an interlocutory order and did not conclusively determine the rights and juror relationship inter se between the parties. Full stop. Thus, comma, even if a relief was given under the said provision to the defendants, comma, the said relief cannot see the light of day or operate in view of the suit itself having changed character from one under section 6 of the 1997 Act to a general suit for eviction of a trespasser upon the plaint being amended. Full stop. Next para. As such, comma, since a relief under section 7 can only be given to a defendant in a suit under section 6, comma, upon partaking the character of a suit for eviction of trespasser, comma, such relief could not any longer inure to the benefit of the defendants in any manner whatsoever. Full stop. Next para. That apart, comma, as discussed earlier, comma, the order allowing the amendment of the plaint was already affirmed by a revisional court and as such cannot be reopened at this juncture. Full stop. Next para. Thus, comma, we find that the conclusions arrived at concurrently by both the courts below, comma, holding the defendant's appellant to be trespassers under section 2 within bracket small g of the 1997 Act does not merit interference. Full stop. Moreover, comma, in view of the above discussions, comma, no substantial question of law is involved in the matter. Accordingly, SAT 11 of 2024 is dismissed under order 41 rule 11 of the Code of Civil Procedure. Full stop. Can 1 of 2025 is also dismissed accordingly. There will be no order as to cost.
I'm grateful.
Thank you. You could have admitted and disposed of the second appeal by now. Yes. Yes.
This is my appeal.
Yes.
Plaintiff is the appellant.
Yes.
Well, the plaintiff is the appellant.
We are still in a dilemma regarding this. Yes, partition.
Well, plaintiff is the appellant before my lord in a suit for partition. Well, preliminary decree.
You are plaintiff.
I'm the plaintiff. Well, preliminary decree passed. Well, declaring my shares. Well, an appeal filed by the respondent and a cross appeal was filed by us. Well, saying that the share which has been adjudicated by the trial court would not be that, but it would be 1/12. That correction was made in a cross appeal. Now, what happened? The appeal of the respondent when taken up, the appeal court has dismissed the entire suit in its entirety, saying that as the parties, what happened, tell your lordship, originally, original owner admittedly by both sides is Mata Prasad Shaw. He had two sons, Bodri Prasad Shaw and Lakshmi Narayan Shaw, owned equally, on death of Mata Prasad Shaw. Lakshmi Narayan Shaw, had one son, Panna Lal Shaw. Now, what I am one of the heir of Bodri Prasad Shaw. Now, the other heirs along with Bodri Prasad and Panna Lal Shaw, sold the property to the defendant number 1. Now, on coming to know this, as we are followers of law, Mitakshara school, we say that could not have been done because on birth, I have a right to the share of the property. That was considered. The
sale deed was also challenged.
Yes, sale deed was in question. I said that whatever share Bodri could have transferred limited to his share, but my share remains. So, declaration of share to that extent and partition as well. Now, in that suit, defendant took a point. You were waiting so long. After the death of Bodri, you have come to court challenging this. So, therefore, your challenge to the share portion should fail. So, this was the only
you are not challenging the sale deed
No,
per se.
per se.
You are challenging. You say that the sale deed was executed, registered, but what passed, we are challenging that.
Yes. So now, trial court proceeded and said, no, it's a Mitakshara school. His share remains. So his share was declared.
Why was the suit dismissed?
Now, in the appeal court, the appeal court said as both the parties in plaint and written statement proceeded admittedly Mata Prasad Shaw to be the owner of the property originally, none of the parties have produced the document showing how Mata Prasad Shaw became an owner. Now, the question, on that point says that therefore the entire sale and everything fails. And dismisses the suit. I just say, if that question is called, because nobody in the trial court raised this question. Now, if that be so, under order of remand, my lord knows if a issue appeal court feels an issue needs to be tried, ought to have remanded back or kept the appeal alive. And
it was a third case actually.
It was a third case actually.
This second appeal will be heard on the following substantial questions of law. 1, Roman 1. Whether the learned judge of the first appellate court substantially erred in law in reversing the decision of the learned trial judge and dismissing the partition suit itself on the ground that the original predecessor in interest of the parties, one Mata Prasad, apostrophes, title was not proved, comma, despite the title of the said Mata Prasad not being disputed by either of the parties, and both semicolon, rather, comma, both parties claiming to the said Mata Prasad, comma, thereby making out a third case beyond the pleadings of the parties. Second substantial question of law, whether the learned judge of the first appellate court committed a patent perversity in dismissing the suit itself on the ground that the title of the original petition in interest of the parties was not proved, comma, despite having allowed the cross objection. You filed a separate appeal or cross objection?
My lord, this is separate appeal.
In
This is a respondent's appeal where my lord, right is affected.
despite allowing the challenge, despite allowing the cross appeal of the respondents,
Cross appeal of the plaintiff declaring correcting the shares.
cross appeal of the plaintiff stroke, you are the plaintiff.
I am the plaintiff.
So the appellants, why respondents?
No, my lord,
Despite allowing the cross appeal of the plaintiff stroke present appellants, comma, thereby modifying the shares of the parties. And full stop. Party shares of the parties, comma, which implicitly recognizes the title of the parties to the suit property. Third, Roman 3, whether the learned judge of the first appellate court, comma, even in the event it was of the opinion that the title of the predecessor of the parties was to be further proved, comma, substantially erred in law in dismissing the suit outright without remanding the matter and or granting further opportunity to the parties to lead evidence on such count. Okay. What is can?
No, can is injunction not to.
One is injunction, one is stay.
One is stay.
Two is injunction. No, two was substitution.
Those are allowed. Those are allowed. Well, all substitutions are allowed. Stay means the prayer. Though nomenclature is stay, prayer. Injunction.
তারপরে লেখো the appellants shall serve copies of can 1 of 2020 within bracket previously can 2592 on an old number can 2592 of 2020 bracket closed, indicating shall serve copies of ওটা বললাম না on the respondents, comma, indicating that the application shall be listed for hearing before the appropriate learned single judge having determination after the timeline fixed for filing affidavits is over, full stop. The respondent shall file affidavit in opposition to the said application, comma, if any, comma, by July 11, 2025, full stop, reply thereto, if any, shall be filed by July 18, 2025. Full stop, next para. The respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in any manner whatsoever till disposal of the application. Full stop, the parties shall maintain status quo as regards possession, comma, also till disposal of the application. The appellant shall file affidavit of service before the learned single judge having determination at the time of final hearing of the application. প্রথমেই affidavit of service হয়
because of the
previous
substitution.
Oh.
Yes.
Plaintiff is the appellant before your lordship.
I am appearing for the
Refusing to grant injunction in connection with the suit for specific purposes of contract. On the ground, my lord, the
injunction was granted.
No, refused.
Refused.
Rejected. My lord, I cannot say refused, my lord, after
application was Mr. Mithra, you take your seat. Will yes.
If your lordship takes up the application for injunction, that there are not all the documents.
You are enjoying ad interim.
No.
Why was it refused?
Yes.
Whether the time is the essence of contract or from that is the
Readiness, willingness.
readiness, willingness, the time is the essence of contract. There, my lord, within that period of time, I am unable to prove before the court below, according to the finding of the court, that I am unable to prove that within that stipulated period, I have offered the entire consideration amount. Pause there for a moment, and my lord, can you turn to the order impugned, that is 14th August 2024.
The delivery of possession also you did not produce any document.
According to us, my lord, we have categorically said the position was delivered to us. Subsequently, it was taken. In my plaint, it has also been stated. Now, my lord, can you consider the order dated page 69, my lord.
Within 3 months time, you did not pay balance consideration.
That is
page 69.
Yes, the order.
Impugn order.
Yes, my lord. This
We'll see from the memo. Yes.
Yes, because all the documents are there. That's why, my lord, I'm doing that.
Yes. Acha, very well. Yes. What is the
Your lordship will find the sale unregistered agreement for sale was executed on 2nd April 2018. My lord will find 3 months is the date for the purpose of executing according to the case of the parties. Now, my lord, it is admitted that the execution admitted and also payment of 5 lakh rupees that was also admitted. The learned court below came to the conclusion, my lord, page 70 at the top. That are unable to prove. Pause there for a moment, and my lord, can you turn to the later
delivery of possession you could not prove? Delivery of possession you could not prove, and consideration within 3 months you could not prove.
Yes, my lord, can you turn to that is only page 76. Just after the time given, the stipulated time, we have wrote a letter to the plaintiff.
2-4 after 3 months.
After just as completion of 3 months.
After 5 months you have wrote. No, more than 5 months. 2-4, 3 months comes to 2-7, 1-7 actually.
1-7.
And you have tendered at the end of August. So
Yes.
almost more than 1.5 months.
1.5 months.
So time was the essence of the
Now,
contract. 3 months.
when the money was kept with them and they returned that earnest money after 20, that amount of the stipulated time, whether it can be termed to be the
What money?
The earnest money, 5 lakhs rupees.
Yes.
That is why, my lord, can you turn to, that is what the letter I have written. At that point, nothing has been said. Now, my lord, can you turn to the next
What
page,
letter did you write?
The execute.
You offered that money.
Yes. And for that purpose, I have annexed the bank documents showing to show that from the very beginning, I am holding that amount with in my bank account. Page 76, if your lordship can consider, this is a letter for executing the registered document. My lord, got it.
You have stated there the several times you requested.
Yes, yes. Now, my lord, in response to this letter, my lord, can you turn to page 78, 14th September 2018 letter, written by the learned advocate.
Yes, yes.
Is no more liable to complete at the time of essence of contract. Rather, my client is ready to pay back the advance amount to the client for whiching 10%. This letter was written on 14/9/2018.
What do they say? Yes.
Yes, because this is 3 months
Yes.
elapsed, so that's why I did.
But say that it is true that they agreed to sell.
No.
Yes, they say.
Yes.
Third paragraph, that it is true that my client agreed to sell.
Yes, they have admitted that the agreement was executed.
Of due amount of rupees 5 lakh within 3 months.
But your client have failed to neglect to make the registration of sale deed by my client.
No, the entire consideration was to be paid within 3 months.
Yes.
But your client failed and neglected to make registration of sale deed by my client by paying the balance amount within stipulated period. There is nothing on record to show that within that period you had tendered the money. Subsequently, you try to manufacture evidence by saying that during that period I repeatedly requested. What prevented you from tendering in writing during that 3 months? Nothing. Prima facie, there is nothing.
The writing is not there.
Nothing.
Writing,
you could write this letter before the 3 months.
Then, if your lordship can consider, then my lord can return to page 81. If the time is the essence of contract, it has to transfer immovable property, my lord knows that the contract of the parties, it can be enlarged. Then also, my lord, can turn to page 81, 10th April 2019, when this amount was refunded. Though we have subsequently we have refunded the amount, then what is the occasion for the purpose of the kept this amount with them after termination of the agreement? If the time is the essence of contract.
That does not automatically mean that time is extended.
By the act.
Agreement required you to pay the consideration amount within 3 months.
Yes,
Mr. Rai. You were required to pay consideration within 3 months. They were not required to return it for the agreement to be cancelled or something like that.
That is what
you cannot put a reverse burden on them.
No, I am on the if you
they would return at the sweet will. Once the 3 months period is over and you don't tender, prima facie, all these are prima facie. You don't tender, then their compulsion under the agreement to execute a deed goes. Then they can take their own sweet time unless you demand.
Whether consider whether this 3 months is the essence of
this was one of the plausible views, Mr. Rai.
Yes, well, so therefore, at this stage.
And you said the position was delivered to you in terms of the agreement. And that also you have failed to prove.
That is subsequently taken. That is mentioned.
You say that it is subsequently taken, but on the
able to prove that is.
It's a plausible view of the trial court. Why should we? The confidence of the trial courts would be shaken if you interfere with these orders.
And 86 is whether I have that amount of money with me from the very beginning or not.
So you are taking 2 points. One is that you have given a letter.
Just after,
you say just after?
1 month after.
Tendering that amount, and secondly, they are late in returning that amount, offering that amount.
After cancelling, by later, that is what precisely I am drawing also.
Cancellation as well as return.
Later of cancellation, 14th September 2018, page 78. And the amount which is transferred.
Not 14th September, 10th of April. 2019.
No, the 14th September 2018, my lord will find the letter written to my client, where it said the question has been cancelled and my client no more liable to complete the transaction. Page 79.
Oh. 79, nothing starts. Oh, 78. Yes.
It starts with 78, my lord. The relevant portion is 79. At the top, my lord will find from there, it has been
stated 3 months is over, you have not paid.
They are cancelled. In lieu, after that, my lord, can you consider 10th April 2019? Why, my lord, I want to draw attention? If there is, by conduct, my lord, it can be proved whether this.
No, they say it has no force. They formally cancel it.
In terms of the conditional
sales. Does not automatically extend the time of the contract.
No, my lord, whether the.
Is the agreement?
Yes. That
was that clause.
Page 72. The relevant clause is at page 73. My lord will find. My lord need not to be traveled. Already the marking underline is there. Straight away, my lord can go to that portion. Now, the cancellation portion, my lord, kindly consider whether there is any clause regarding the cancellation.
But there is the main point you have not taken, Mr. Rai. There is nothing
regarding cancellation.
Not only cancellation, no negative effect that automatically.
That it will be cancelled. That is the point of.
Not only cancellation, we need not go to that extent, but that this agreement will lose its force or.
Yes.
Time is the essence of
contract.
As far as they are concerned, yes. But they rather say, উক্ত সময়ের মধ্যে টাকা বুঝিয়া পাইবার পর registration না করিয়া দি, তাহলে you can have it registered so and all these things. So
but the agreement should cancel money, that is not there.
Mr. Mitru, time, it's arguable as to whether time is the essence of the contract. There is nothing, no penalty for not paying the money within time. He should have started with this.
Yes, ma'am.
Unnecessarily wasting time of court. And Mr. Mitru. Too many matters, Mr. Rai, nowadays.
My lord, this has been
This is the best point.
Best point, my lord. So far as 14th August is concerned, the order was passed. In the meantime, I have also transferred the property to someone else.
After filing of the suit.
After filing, my lord, this was transferred 29th May 2025, my lord.
Has
This
it been disclosed
application-
anywhere? You are disclosing this for the first time here.
For the first time, we came to know also, my lord, from my client.
Appeal has become infructuous.
No, my lord, so but
Will
this-
permit you to renew the same prayer against the transferor. But then you have to set aside the order.
well, can you consider it another way? This is the appeal is pending, suit is pending, the lease pending transfer.
Yes, there is no bar.
There is
Bar does not operate. It has been held by courts that
that
does
can
not
be done.
the transferee will be bound.
Transfer will be bound. So therefore, my lord, I am praying for not to change the nature and character. At least that
That
portion,
is not automatic. When you filed the injunction, there was no prayer against the transferee.
there is no transfer affected. It is subsequent.
Subsequently, now after knowing that there has been a transfer, how
Now,
can
that is why, my lord, even two things, my lord, can you consider? One is the transfer portion, one is the changing the nature and character. It is suit for contract of a sale, not a development.
that
agreement.
party, that third party is not even a party to the appeal or the suit.
He's
How can
bound
you restrain him?
He is bound by the order passed
You
by
have to
the
add him. For someone to be bound by this is not something in rem. He is bound, generally bound. Whatever will be the outcome of the suit, if the court decrees the suit for specific offense in your favor, yes, he will also be embroiled in it. You have to implead him because he will execute the deed. He will be a confirming party. But we can't grant injunction. This has become infructuous.
Then, my lord, if you logically consider, if this order stands,
Yes, then you will.
then I will be.
Suited to tumra appear steps in.
Mr. Mitro, we find that a prima facie case for injunction was made out. We'll hold that. If you agree, we'll dispose of this appeal. But we'll set aside this order. But even after setting aside on merits, we'll set aside the reason we are giving you. Is that nowhere in the agreement it is mentioned that time is the essence of the contract, insofar as they are concerned. So therefore, that is the reason why we will set aside this order. But after setting aside, we will say it has become infructuous since we will record your submission and we will give the particulars to him within a day in writing. The infructuous due to that reason, we will give him liberty to ask for similar injunction by impleting the transferee as a party.
So the my lord can add the
At whom?
the
Mr. Mitro as a party.
My lord, right. If the parties who have been transferred, that can be added from here. Otherwise, order rule 10 again.
Since substantial questions of law, since several questions of law and fact are involved in the appeal, the same is admitted to be heard on the grounds taken in the memorandum. Next para. In view of the peculiar circumstances of the case, we take up the appeal itself for hearing along with the connected application by dispensing with unnecessary formalities. Next para. At the outset, learned counsel appearing for the defendant respondent points out that that in the meantime, the suit property has been transferred in favor of a third party. Next para. Although we are of the opinion that the plaintiff appellant should be at liberty to implead the third party and ask for an injunction against the said third party, it is rightly pointed out by learned counsel for the appellant that unless the present appeal is decided on merits, insofar as the legality of the impugned order is concerned, the said order would deter, DETER, the plaintiff from getting an order of injunction on the same principles, against the transferee as well. Accordingly, we take up the appeal on merits. Next para. The learned trial judge dismissed the temporary injunction application of the plaintiff/appellant on twofold grounds. First, that the appellant failed to produce any document to prove that the appellant is in possession of the suit property, despite the plaint case that possession was delivered along with the execution of the agreement, of which specific performance has been sought in the suit. Para. Secondly, the appellant failed to produce any document to show that balance consideration amount was paid within the period of 3 months as agreed in the agreement. Full stop. Next para. However, comma, we find from the materials on record and from the submission of parties that the plaintiff appellant has made out a case that although originally possession was delivered simultaneously with the execution of the agreement, comma, subsequently the plaintiff stroke appellant was dispossessed by the defendant. Full stop. The veracity and correctness of such case has to be tested by a full-fledged trial, and it would be premature to decide such question at the present juncture. Full stop. Next para. In any event, comma, the said issue is a non-issue insofar as the injunction is concerned, comma, in view of the existence of a written agreement between the parties. Full stop. Next para. The primary consideration of the learned trial judge for dismissing the injunction application was that the balance consideration was not paid by the appellant within 3 months as agreed in the agreement. Full stop. Next para. However, comma, we find from the relevant clause in the said agreement that there was no mandatory provision in the said agreement that the balance consideration has to be paid within the said period of 3 months. Full stop. Rather, comma, the defendant agreed, now defendant stated in the agreement that the defendant would execute a registered deed of sale in favor of the plaintiff stroke appellant in the event the balance consideration was paid within 3 months, and in the event the defendant failed to do so, comma, the plaintiff would be at liberty to have the deed executed through court. Full stop. Next para. However, comma, the contrary is absent in the agreement. Full stop. There is no sanction in the agreement in the event the consideration amount was not paid within the period of 3 months. Full stop. It is nowhere stated in the agreement that if such payment was not made within the stipulated period of 3 months, comma, the agreement would stand cancelled or lose its force. Full stop. Next para. Such aspect of the matter was entirely overlooked by the learned trial judge, comma, just as it overlooked the documents produced by the plaintiff by way of correspondence indicating that soon after the period of 3 months was over, comma, the plaintiff wrote to the defendant offering to pay up the entire balance consideration and iterating that such offers were made even previously several times. Full stop. Next para. Moreover, comma, the defendant, comma, much subsequent to the period of 3 months, comma, purported to cancel the agreement. Full stop. Also, comma, as argued by the plaintiff stroke appellant, comma, the earnest money of rupees 5 lakh, which was admittedly paid simultaneously with the agreement by the plaintiff, was not returned by the defendant within the stipulated period of 3 months or immediately thereafter. Full stop. Next para. Such factual aspects of the matter raise sufficiently strong prima facie case for grant of injunction, and as such, comma, we are of the opinion that the learned trial judge erred in law and in fact in dismissing the injunction application, temporary injunction application of the plaintiff. Full stop. Next para. We make it clear that we would have otherwise allowed the said application by setting aside the impugned order and granting the injunction to the plaintiff stroke appellant as prayed for in the suit, comma, unless it was pointed out to us that the property has been transferred to a third party who is not a party either to the suit or the present appeal, comma, in the meantime, full stop. As such, comma, any order of injunction passed against the defendant would be toothless ab initio, since no useful purpose would be served in injuncting the defendant who has already effected a transfer in respect of the suit property. Full stop. Next para. Accordingly, comma, although for entirely different reasons, comma, we are unable to, and we are loath in interfering with the impugned order. Full stop. Next para. FMA 1146 of 2024 is, comma, accordingly, comma, disposed of by holding that the impugned order is otherwise illegal and erroneous in law and fact, but stopping short of setting aside the same only in view of the transfer having effected in respect of the suit property in the interregnum by the defendant in favor of third parties. Full stop. Next para. However, comma, the plaintiff stroke appellant will be at liberty to seek self-same injunction in respect of the third party to whom the property has been transferred by the defendant in the meantime, by impleading the said third party as a party to the suit. Full stop. The name and particulars of the said transferee shall be disclosed in writing to the learned advocate on record for the plaintiff stroke appellant in this court by the learned advocate on record for the defendant stroke respondent by June 26, 2025, to enable the plaintiff to implead the said third party as a defendant in the suit and to renew his prayer for injunction against the said added party. Full stop. Can 1 of 2024 is disposed of in the light of the above observations? No rest to question.
But I have already intimated him the name of the task.
Formally, Mr. Mitro, just in
Give the
writing,
letter, otherwise one
in a letterhead, just do it. Otherwise, that will be the basis of their order 1 rule 10 application.
application. ওটা না miss করলে হবে না। আমি দিয়েছি
না।
আপনাকে বলে দিয়েছি।
Disposal, হ্যাঁ। Judgment, হ্যাঁ।
36 minutes, I'm appealing for the appellant. Lord, may I come back tomorrow? May I
On
come
the
back?
prayer of the appellant, the matter is adjourned for the day.
But I will
36
this one.
For the appellant.
But item number 36, my lord, I am praying, my lord, appellant may be directed to serve a copy upon, my lord, I am for the response.
Of what? You have lodged the caveat?
No.
Then
I am, my lord, I understand.
you write a letter, you give a copy? Yes.
For the appellant in this matter, but there is a defect. The defect asked also. It's shown that there is a defect, but I'm really not aware what the defect is.
What is the appeal against?
Appeal is against not an order of appeal, dismissal of an appeal against an order.
Please take the microphone a bit closer.
Yes, Lord, rejection of an appeal filed by me against an order, against a decree for eviction.
You are the defendant?
I'm the defendant.
Both courts, lost in both courts. Eviction on the ground of?
Eviction on the ground of defaulter, reasonable requirement, and my lord notice. Now,
All grounds, you are evicted on all grounds.
it has been shown. Possession has been also. No, yes, the only, if the appeal is taken up, but I can show
No, reasonable requirement, default and?
reasonable requirement, default and notice has been found to be good. I say and the notice has been found to be good. The notice under 6.4 has been found to be good. I say
No,
it's
what
bad.
were the grounds of eviction?
Reasonable requirement and my lord,
On
default.
both grounds, it was evicted. You are evicted.
I have been found guilty on both grounds. I have lost on both the grounds.
So you did not take resort to 7-2?
7.2. That is the question. My lord,
Your defense was struck out under 7-3.
My lord, the defense was struck out under 7.3. My lord, 7.2 was filed late. It was late in time. 7.2 went away. Now, my lord, the interesting part. If your lordship nevertheless, my lord, he has to prove that my lord, a default has occurred. The finding of the learned trial court, if your lordship kindly takes the
You have
finding
to
of the learned
satisfy
trial
us
court.
on both points.
Yes, I will try my best.
Requirement as well as...
I'll try my best. So the learned trial court has found that I have committed default only because my 7.2 application was rejected. And there is an incorrect finding on fact that 70 application was disposed. I failed to comply, and hence I was held as defaulter. That is the exact finding.
What
verbatim.
was actually happened?
It was it was rejected because it was out of time.
7-2.
7-2. It was carried in civil revision application before this honorable court.
Go on complying with 7-1.
Not 7-1. I said that there is no.
You have to go on complying with 7-1. Last paid rent.
My lord, 7-1. Yes, my lord, I had continued
Therefore,
payment.
defense was also validly struck out on that ground.
Yes, I had continued payment in the before the learned rent control. Before the learned rent controller. After the court deposit.
After filing of the suit.
That was affirmed by Justice Sanjeev Banerjee.
Which was that?
Rejection.
717.
7-1, 7-2 both were rejected. No, 7-1 no application is necessary. Even if that is rejected, they have to continue with 7-1.
Yes.
Deposit 7-1 only contemplates a
They did
deposit.
not deposit any money.
I said that my lord, there is no default. I
Why?
said there is no default, hence 7-1.
You went on depositing money.
I went on from, yes, my money order was sent, refused, and my case is that I went on depositing before the land rent control. Now in 7-2 application, I came to deposit it before the.
You continue depositing before the rent control under what provision? After the filing of the suit?
My lord, it was started. The deposit was started before the filing of the suit, right? The deposit was started before the filing of the suit, but the receipts were never produced. That is one default on my part. The receipts are never produced.
These are not questions of law.
These are not questions of law. But the question of law, if I may, my lord,
3 months within a period of 12 months. Was there any finding that you are a defaulter in payment of rent for 3 months within a period of 12 months?
Kindly takes up the finding which has been found by the learned trial court. If I may, my lord, place. My lord, at interim page, my lord, if your lordship has the, my lord, the judgment of the learned trial court, at interim page 12, while deciding issues number 3, 7, and 8, and in the second paragraph, it holds the learned.
No, you also challenge the 7-3 order.
7-3 order.
Page 12.
7-3 order was.
7-3 order, there you filed 2 COs against the rejection of 7-2 and 7-3 order.
My lord. So my defense was struck out. There is no dispute to that. But the finding is, my lord, if your lordship now kindly comes to the finding portion. Page 15, internal page 15. Defendants, the defaulter, as they have failed to comply the order passed by this court in application under 7-2.
What about reasonable requirement?
Yes, my lord, I am just showing that. Reasonable requirement was not taken up as, my lord, points, issues number 5, 4, and 5. Four and 5 is at page 9, my lord. Internal page 9. And my lord, the finding is, my lord, in the next page.
Oh, these are bad findings. Court says that the not inclined to take these documents because the defense has been struck off. Plaintiff has to prove his case on merits. You're right. How does the appeal court deal?
Appeal court. Your lordship now kindly comes to
Independently, they have to prove that just because the defense has been struck off does not mean automatically.
Now, if your lordship kindly takes up the certificate copy.
আর যেতেও ক্ষেত্রেও ধরুন 7-3 তে চলে গেল কোর্টকে অ্যাটলিস্ট একটা লাইন তো কনসিডার করতে হবে যে ও 7-1 এর কমপ্লায়েন্স দেখুন 7-1 এ কিন্তু অ্যাপ্লিকেশন কন্টেমপ্লেট করা নেই ও 7-2 টা রিজেক্ট হয়ে গেল বিয়ন্ড টাইম করেছে বলে দেখি একবার 7-1 এ কি বলছে
if your lordship kindly turns to internal page
রিজনেবল কিন্তু ডিফল্ট একবার দেখিনি But 7.1 also B says you have to deposit within 1 month. 7.1 deposit also. And thereafter month to month.
I filed an application under 7.2, my lord, subject to correction.
7.1 also you are out of time.
My lord, 7.1, if I deposit, it has to be followed by an application under 7.2. Now I said, my lord,
Both were
subject to
rejected
correction, subject to correction.
because of time. But suppose 7.2 actually when you raise a dispute either regarding quantum or relationship, then you can 7.2 was rejected. You can understand even if 7.2 was rejected, under 7.1 you had been complying with by paying monthly rent. But for that also 7.1b provides, present 7.1b, such payment or deposit, this is payment under section 7.1, shall be made within 1 month of the service of summons or where he appears in the suit within 1 month of the appearance. Thereafter continue to pay to the landlord or deposit month by month.
But there is an admitted default. There is an admitted amount of default. But there is no admission on my part.
What admission?
I did not say that the
Yes, 7.170 has been rejected.
that has been rejected.
After affirmed up to this court as
Affirmed
time
to
barred.
this court, so I cannot, I'm not.
There was no compliance of 7.172.
7.172, I'm not on, my lord. Rather, my lord, I am saying that 7.172's rejection has been held to be an embargo on me.
So if you come to the ground of default also under section 6b, let us come to 6b, which is the default, which is the ground of default in payment of rent. 6b says where the tenant has made default in payment of rent for 3 months within a period of 12 months or for 3 rental periods within a period of 3 years. So because your first deposit was time barred under section 7.1 or 7.2, whatever you say, there could not be any valid deposits after that. So automatically B comes in.
And my lord, my striking out of my defense, that point still remains. Striking out of my defense, my lord.
Defense has been struck out, affirmed up to this court.
That I cannot challenge any further.
No, you are right. Just because your defense was struck out, automatically it could not be said that reasonable requirement point is also established. They had to establish. Reasonable requirement were satisfied that the trial court was incorrect. But regarding default, it's automatic in the sense that here your 7.1 and 7.2 was together rejected as time barred. So therefore, there was no deposit under 7.1b at all. If there was no deposit under 7.1b, there could not be any subsequent deposit. There automatically was a default in payment of rent for 3 months within a period of 12 months. That is the difficulty.
Back on that one. On that question, may I come back? What I was thinking is, if I continue to deposit before the rent control, then perhaps if I could show that.
Rent control deposit, how does it validate your
I need
default?
to come back on that. I'll be very
No question of coming back.
On that question.
No. After hearing on merit, we cannot. Sorry, we have formed an opinion now. No.
Then if you lordship kindly
Under which provision do you say that you could deposit before the?
এখন কোর্টে জমা দিচ্ছি কি করবে 7 to admit করবে
Let us see how the appeal court dealt with it.
But my instructions are that, my lord, 7.1 was, my lord, allowed. And thereafter I continued to deposit before the learned trial court, and it is still and that has continued.
Have you got a copy of your 7.172 application?
7.172 application, lord.
You must have that before formulating the grounds. You should have.
The plaint. No, it is not in the stay application, lord. I can produce a copy.
See whether you have got a copy.
I can produce a copy.
তো কপি পেস্ট করে দিয়েছে অ্যাপিল কোর্ট, ট্রায়াল কোর্টটা কপি পেস্ট করে দিয়েছে নাকি ভুল করছি? না দুটোই তো ওই সুটেরই। You have not annexed the order of the appellate court? Yes. আছে। অ্যাপিলে কি বললো? এই তো 7, yes, yes. Please come to page 2 of the appeal court. During the hearing of the suit, 7.1 and 7.2 applications were preferred, and same were heard and disposed of, where the defense was struck off. So 7.1, 7.2 both were disposed of. This court took up both the revisional applications and rejected both.
Lord, if I may first address the question of reasonable requirement, if your lordship kindly takes up the order of the appeal court, it is in the second paragraph. What I prayed for is really an adjournment that was not given, understandably so. Thereafter, my lord, the submission of the respondent is recorded, and the learned appellate court, my lord, proceeds entirely on the submission of the respondent. Lordship kindly takes up the later part of the second paragraph at page 2, internal page 2. I'm reading from it. Appears that the learned counsel for the appellant was not inclined to make submissions on the ground that he is led by such and such, who is out of court. However, learned counsel for the respondent is present and submits that the main objection, as has been raised by the appellants in the present appeal, is that the possession was taken away by the plaintiff without informing the daughters and wife of the deceased defendant, namely such and such. According to the learned counsel for the respondent, the tenancy was given to two persons, namely such and such and such, who were not related as family members. Now, this is a submission made on behalf of the respondent. Thereafter, the facts are recorded. The facts of rejection of 7.1 and 7.2. And finally, in the next page, at internal page 3, my lord, in the second paragraph there, perhaps the reasoning begins from there. But it says, now the law is very clear that in case of the event of death of one of the joint tenants, the tenancy right of deceased tenant devolves upon the surviving tenant. But pausing here for a moment, my lord, joint tenants, this was never a case made out. And my lord, the notice, eviction notice, was admittedly served on both the tenants separately. So, my lord, perhaps, my lord, there was no unification of, my lord, tenancy here. My lord, continuing, in such view of the fact, the decree holder was not required to give any notice to the wife and daughters of the deceased such and such of the joint tenants. However, the present appellants, being the wife and daughter of such and such, entered appearance and made application for restoration of possession, and the same was dismissed against which they had preferred the revisional application being such and such before this Honorable High Court. And the Honorable Court, upon contested hearing, the civil revision was dismissed and the revisional application affirmed the order of the executing court. Thereafter, the executing court has passed the order in favor of the decree holder in the application for police help. Thereafter, the possession has been taken away. Now, it is only based on these that the learned appellate court says, in view of the facts narrated hearing before, the court is of the opinion that nothing remains to be heard in the appeal. So, my lord, it has really, in my humble
No, we'll admit the appeal. There are questions of law. The present second appeal shall be heard on the following substantial questions of law. 1. Whether both the courts below substantially erred in law in granting a decree of eviction on the ground of reasonable requirement of the defendant stroke plaintiff stroke respondent merely on the premise that the defense of the defendant stroke appellants had been struck off under section 7 within bracket 3 of the West Bengal Premises Act 1997, without adjudicating independently on merits, on the basis of the evidence on record, as to whether there was any such case of reasonable personal requirement being established by the plaintiff at all. Roman 2, whether both the courts below substantially erred in law in granting a decree of eviction also on the ground of default in payment of rent merely on the basis of the fact that the defense of the defendant stroke appellants was struck out due to filing the application under section 7 within bracket 2 of the 1997 Act beyond time, without independently ascertaining from the evidence on record as to whether the provision of section 6 within bracket small b of the 1997 Act was satisfied, by adverting to the records to satisfy themselves as to whether the defendant stroke appellants had been going on paying rent within the contemplation of section 7 within bracket 1 of the West Bengal Premises Tenancy Act 1990 আচ্ছা এটা দরকার নেই এই লাস্ট পার্টটা দরকার নেই by ascertaining from the থেকে কেটে দাও ওই যেটুকুনি বললাম third whether both the courts below whether the learned judge of the first appellate court committed a substantial error of law in failing to advert to any of the issues involved in the suit and proceeding merely on a third issue, comma, on the basis of the case made out by the appellants in the execution case in connection with the suit. What is the application you have made? You have already, there is no scope of stay because you have already taken position.
Yes, and my lord, second thing is
so that no
this,
third party interest is
whether
no
the
further
present
transfer.
appellant has got any right over the property or not to file this instant appeal. Because
not?
they are the heirs of this is defendant number 1.
The
And
notice,
there is the abutment in the plaint, page 10.
Yes.
Your lordship will find that the defendant are the joint tenant. Last but one line.
After the appeal is admitted, learned counsel appealing for the defendant plaintiff stroke respondent raises a question as to the locus standi of the appellants to prefer the appeal in the capacity of heirs of the defendant number 1.
This is defendant number.
Full-stop learned counsel for the respondent particularly points out to the averment in the plaint in paragraph number 10 of the plaint.
Paragraph number 1.
Paragraph number 1 of the plaint to the effect that the defendants were joint tenants. Full-stop next para. Such question shall be such question is kept open to be argued at the final hearing of the appeal. Full-stop next para. Can you have filed a can?
yes, the can is only for my lord, so that no further transfer is committed, so that
Achha.
prevent any further transfer.
It is can 1 of 2025 is now taken up for hearing. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we are apprised that, comma, in pursuance of the impugned eviction decree, comma, possession has already been taken by the plaintiff stroke respondent. Full stop.
By way of execution.
Pardon?
By way of execution.
By due process of law. Full stop. Next para. In since the a prima facie case for hearing of the appeal on merits has been made out, and the balance of convenience and inconvenience is in favor of grant of injunction, comma, there shall be an order of injunction restraining the respondent and or his men and agents from selling, transferring, alienating and on encumbering the suit property in favor of third parties in any manner and or parting with possession of the same till disposal of the appeal. We are granting this because there was no case, your case was for personal requirement.
Personal requirement.
So therefore,
You cannot say anything that I can.
yes,
I can.
otherwise we would not have passed this. Full stop. Next para. The appellant shall, in view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for hearing for inclusion before the appropriate learned single judge having determination as and when the same is ready for hearing.
My lord, default clause kindly.
Pardon?
Default clause. Default. If they do not file.
You have not imposed any condition. What is the question of default? You enjoy the property, but don't transfer.
So deeply understood.
That's for my business purpose.
Absolutely.
Much.
Deeply understood.
Can such and such is disposed of accordingly.
I'm good.
Thank you. Without any orders to prosecute. Thank you.
Kindly don't take me. I miss not for that prayer of not coming back. I was really unprepared on that question.
No.
I'm so deeply obliged.
Defects removed.
And not there were defects not in the appeal. Not,
Thank you for pointing.
I'm not really sure what the defects were.
I go. Name of defendant number 2 in the certified copy of the decree of the suit does not find place in the cause title. What about that? There was a defendant number 2 also.
Yes, yes.
Has to be made a pro forma respondent. Who is Farhad Ali Mullik?
Yes, he is not contesting.
Then the appellant not now. The only
Other than the appellants, one stranger named Farhad Ali Mullik executed the wakalatnama.
Oh, they include as appellant.
Farhad Ali Mullik
has
is
been
number
named.
2.
Yes.
Farhad Ali Mullik has been
And
added
he
as
is not
number 2.
signing any vocal.
Then he just has to be added as an appellant because he has already filed wakalatnama.
He has filed vocalatnama.
The second defect is other than the appellants, one stranger named Farhad Ali Mullik executed their wakalatnama. So therefore, they have already the wakalatnama without implementing as well. Farhad Ali was a defendant number 2.
Yes. And he had appellant number 2 also.
No,
Yes.
he has not been made an appellant. That is the difficulty.
Can application kindly see?
Can they have made a party in the memorandum? They have not made. Huh. Yes, exactly. You have just omitted the name of Farhad Ali Mullik in the memorandum. Please leave his the learned advocate and record for the appellants is directed to include the name of the respondent number, include the name of appellant number 2, Farhad Ali Mullik, in the memorandum of the appeal. Full stop. That apart, comma, leave is granted to the said learned advocate on record to insert the name insert the details of the judgment and decree of the trial court in the memorandum of appeal.
Practically, Farhad Ali Mullik has not contested in the appeal also.
Maybe, but he may prefer an appeal. No, that does not prevent him from preferring an appeal. So you will have to just add immediately do it. Appellant number 2 will be added. Farhad Ali Mullik, copy from your stay application, as your learned friend rightly pointed out.
I'm grateful.
And what is this in the memorandum you have stated? Chief Judge, City Civil Court at Calcutta, thereby affirming. Where will that be? See the preamble of the memo.
I don't have any memo.
You have to state.
It's a memo to the application.
Preamble of the memo. Should you have to teach you these things also? You're moving a second appeal. You don't look through the memorandum, the preamble of the memo. Preamble of the memorandum.
Do you have a memo?
What are you looking at?
But the memo is not the copy memo.
Show your learned friend. He will tell you.
Not even with me.
It is not done like this. Judgment, impugn
City
judgment
Civil
and
Court
degree
memo.
passed by such and such on such and such
Where is
in
this
title
memo?
appeal, comma, thereby affirming the judgment and degree of the trial court.
Memo of appeal, they made party Farhad Ali Mullik as appellant number 2.
In their copy, not in our copy. They only feel that the judges should be left out. No, in the preamble, give us a copy of the memo. Oof. Let us not waste time on this, please. Give a copy of the memo. After this, January 30, 2025, please write thereby affirming the judgment and degree dated such and such, passed by such and such. Do it right now. This matter is over. Next call the next matter. Unnecessary wastage of time.
With your lordship, please.
Thank you. Yes. And thank you for pointing out the defects.
38, I am for the appellant.
Yes.
Being
Yes,
the
Mr.
plain-
Datta.
being the plain-
Mr. Basu.
Appellant plaintiff, my lord, the judgment of affirmance, the suit for partition was dismissed. We 5 brothers, plaintiff and defendant number 1 to 4, jointly purchased the scheduled property
1 to 3. Then how
One-
can it be 5?
1 to 4. There are 5
1 to
brothers,
4. Yes.
1 to 4 of the defendants. We jointly purchased the property from the recorded owners. There was a defect in the record of rights of my vendor. For that reason, the BLRO was made a party. The trial court, in the defense, they took the point that the plaintiff have never purchased the property, although his name was implemented at the request of the mother. For the reason that the father,
Oh, we don't understand. Whose name was?
my name was included in the deed, purchase deed, along with the defendants, only at the behest of the mother.
How does the mother come in?
Mother does not come in because the record, because the title deeds have shows that we all 5 brothers have purchased. That is the defense taken by the defendant. They have not proved their defense because none of the defendants have graced the witness box. And the reason for
They cross-examined you.
they never appeared. They only filed the written statement. They cross-examined.
You have proved your case.
The trial court dismissed that I could.
No, you adduced evidence.
I been the PW1. I have adduced evidence.
And you are cross-examined.
I have been cross-examined so far as plaintiff is concerned, but so far as the defendant is concerned, they never graced the witness box, nor they proved their defense case.
But they cross-examine your witness.
Yes, my witness.
Very well. Yes, trial court held what?
Trial court dismissed only on the ground, which my lord may kindly comes to the order of the trial court. Internal page 3. Internal page 3 of the trial court judgment.
4-page judgment. 4-page.
4-page judgment. Yes.
Very good. Yes.
The 3rd page, my lord, the first paragraph, kindly skip the first few lines.
Yes.
1, 2, 3, 4, 5 lines. It starts with I find. My lord has got it.
Page 3.
Page 3, first paragraph.
Yes, I find.
I find that the plaintiff has failed to prove para 2 and para 10 of his plaint. That is the LR informations which are exhibited 2 by 1 and 2 by 2. Plaintiff has exhibited Khazna Dakhilas as exhibit 1 by 1 and 1 by 2. These Khazna Dakhilas have Khatiyan number 1159 by 1 and Khatiyan number 1189. These documents have not
You
been...
did not mark your title deeds as exhibits.
That those who have been produced. But at the relevant point of time, somehow it has not been proved. That has been marked for identification. Then
Mark for identification does not mean anything.
No, it does not. But I can take out an application under Order 41 Rule 27, my lord. That opportunity I have. And that was
But that opportunity, did you avail of that in the appellate court?
That has not been taken off.
Then, for the first time in the second appeal, why should you do that?
My lord, for the
you have to do it before the appellate court.
For Order 41,
your suit has been dismissed because you failed to prove your title.
No, the suit has been dismissed only on the ground, but the plaintiff has proved. Kindly see paragraph page 4.
Yes.
Second line, but the plaintiff has failed to prove that Mohitosh Bishas, my vendor, and Vibhuti Bhushan Bishas, it has gone down as Bipad Bhanjan Bishas, were the owner of the suit property in equal shares, and he, that is the plaintiff, is a co-sharer in the suit property. I am a co-sharer because the deed all the 4 deeds stands in my name along with the defendants. That is an erroneous finding.
No, you have failed to prove that you are an owner of the property or a co-sharer because your deeds were not exhibited.
But those
X, Y, Z.
But that, in my respect for that is a curable defect under Order 41 Rule 27B. If my lord may kindly take into consideration the provision of Order 41 Rule 27, A may go against me. But so far B is concerned, my lord, that still is in my favor.
B, if you only feel.
My lord may kindly see the Order 41 Rule 27B.
B, only if the court feels.
Yes, only the court feels.
Not as a matter of right, sorry. Why should we fill up your lacunae? That is also settled. B 21(7)B, 41(27)B should not be used to cover up the lacunae of a negligent plaintiff. You fail to prefer rather Order 41 Rule 27AA permits you to do that also if it was not taken.
Yes, that was been exhibited. That was
not A. A is the court. If the court from whose degree the appeal is preferred, then you are very well. Let us. That had to be done by the first appellate. How did the first appellate court deal with it? Let us see.
Kindly see the findings of the first appellate court. Your lordship will be very
astonished. We are no longer astonished with anything.
Page 5 of the first appellate court, paragraph 10.
Yes.
Kindly see the 3rd line. That he did not make any prayer in the respect of the share of the dependent in the suit property. That is prayer A. That is wrongly been said. That I have not made any prayer in respect of the share of the defendant. I have said I am entitled to 1/5 share. That is out of 39 decimal. I am entitled.
You have not asked for partition by meets and bound.
No, yes, prayer B. Prayer B of my plaint. Kindly see the stay application. Prayer B of the plaint, your lordship will get the
What does the court say? No final degree you have asked.
No, kindly see. That is the erroneous finding, my lord. Plaint at page 46. Rather, your lordship will get the prayer at page 48. The page paragraph 13A, that a preliminary degree of partition be passed in favor of the plaintiff in respect of his share 18.06 decimal in the shoot property
Yes, yes, you asked.
against the principal defendant.
Yes, yes. Yes.
And the principal defendant fails to make amicable partition, then survivors commissioner be appointed for effecting final
This
partition.
second appeal will be heard on the following substantial question of law. Whether the title deeds produced by the appellants, by the plaintiff stroke appellant to prove his title, comma, including the documents which is marked as X, comma, Y, comma, Z and Z1 for identification, should be permitted to be admitted in evidence by proper mode of proof within the contemplation of Order 41, Rule 27, within bracket 1, within bracket small a of the Code of Civil Procedure. Next, Roman 2, whether the courts below substantially erred in law in dismissing the suit on the technical ground that the title deeds of the plaintiffs, comma, although furnished before the court below and marked for identification, were not marked as exhibits, comma, without granting an opportunity to the plaintiff to so mark the documents, comma, particularly in view of the defendants, respondents having not adduced any independent evidence in support of the defense case, but merely having cross-examined the plaintiff's witness. Next para. Since the prima facie case has been made out, comma, the appellant shall serve copies of Can 1 of 2025 on the respondents, on the defendants' respondents 1 to 4, indicating that the application shall be listed before the appropriate learned single judge having determination after the timeline for exchange of affidavits is over. Full stop. Service on the pro forma defendant stroke respondent number 5 is dispensed with for the present. Full stop. The defendant respondents 1 to 4 shall file their affidavit in opposition, comma, if any, within July 11, 2025. Reply, if any, thereto shall be filed by July 18, 2025. Full stop. The respondent numbers 1 to 4 and their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating and or dealing with or creating any third party interest in respect of the suit property in any manner till disposal of the application. The appellant shall file an affidavit of service before the learned single judge when the application comes up for final hearing.
My lord, may kindly call for the records.
We'll direct that right now.
My lord.
The appellant shall put in due requisites for service of notice of appeal on the respondent numbers 1 to 4 as well as the pro forma respondent within a week from date. Full stop. The trial court record shall be called for by special messenger at the cost of the appellant, comma, also to be deposited within a week. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the appellant to mention the appeal for inclusion in the list of the appropriate learned single judge as and when the same is ready for hearing.
Much obliged.